Ladies and gentlemen, lend me your ears and your eyes. Diva Divine Light, live from Brooklyn, New York.
With no delaying to what you saying, yo. Said it with my 9 million with the dilly, yo. When I be on my guess I do my duty, yo. While up in the club, every while in the studio. You don't wanna violate, nigga, really and truly, yo. My main thug, nigga named Julio, he moody, yo. Like a nigga that'll slap me with the tulio. Bitch, nigga scared to death, act fruity, yo. Fuck that, nigga, shorty, she a little cutie, yo. The way you shake it, nigga, wanna get all in the booty, yo. With no delaying to what you saying, yo.
Diva Divine Light.
Really my heart to me. That's what you got for me. Put more than years with my eyes to see. Still $1 in a place to be. If you really my heart to me. That's what you got for me. Put more than years with my eyes to see. Still $1 in a place to be. If you.
You're watching Diva, the Divine Light. A fun-loving, caring, passionate person who talks about sex, celebrity, and real-life issues, and even abuse. So hit that like button and make sure you share the show.
Really my heart to me. That's what you got for me. Put more than years with my eyes to see. Still $1 in a place to be. If you really my heart to me. That's what you got for me. Put more than years with my eyes to see. Still $1 in a place to be. If you really my heart to me. That's what you got for me. Put more than years with my eyes to see. Still $1 in a place to be. If you really my heart to me. That's what you got for me. Put more than years with my eyes to see. Still $1 in a place to be. If you.
Here comes the pitch, and it comes in wide. On the go ball.
Hello, 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 everyone. Welcome back. Welcome back. Give me a thumbs up, please, and let me know that you guys can hear me. All right, there's sound now. You guys hear me? Thank you, guys. Sorry about the technical difficulties earlier. I just received a notification on RSK's trial here. I'm going into Pacer right now to see what it is exactly. So before we get into anything, let me, okay. So we all know that Ms. Bonjean had put in a letter, right, for a motion for extension of time to file a supplemental Rule 33 motion for R. Kelly, right? And 33 motion, as we know, is for a new trial. So today, it says that order granting 274 motion for extension of time to file the defendant's supplement Rule 33 motion, if any, is due by March 21st, 2022. And Judge Donnelly also said that no further extension will be granted. So, Bonjean only has this one extension. She cannot ask for any more extensions. Judge Donnelly granted her motion for the extension and gave her till March 21st, guys. So that's the latest news. I will put this information up on my community wall later for those who missed the live or who want to see the information. So once again, hello everyone in the building. Hello, Indigo. Hello, Mountain of Inspiration. Chocolate, honey. Noonie, what's up, mommy? Granny, hey, baby. Rocking with the truth. What's up, sis? What's up, Truth Strong Warrior? What's up, my love, my baby girls? What up, homie? Why theory? That's my children in the back, my son and my husband. They're behind me and they're watching Encanto. So please forgive me. Oh, I thought you guys were watching that. Okay, now they're watching me. I apologize about the noise in the background, guys. Y'all already know my life, my busy schedule. I have one room and we're all in the same room right now. So the son is hanging out with the dad and they're watching TV together, bonding. The girl's in the room doing her thing, hanging out with her friends online. She's done with work. They're both done with schoolwork and now they're chilling. Yes, I live in a very active household. And welcome, by the way. Why I don't know what that says. YM? Does that say YM has a theory? Welcome to my channel. Enjoy the show while you're here. Over here, we like to learn. We talk about R. Kelly and his trial. We are not for him, we are against him. And welcome to the channel. And say hello to my OCOV family in the building. Shout out to everybody, OCOV. And shout out to everybody else in here. What's up? Shout out to those in the bushes. Thank you for coming. To my haters, I love y'all. Thank you. Make sure everyone hits that like button, please. Thank you. Now, another thing I wanted to talk to you guys about was today, I wanted to talk about voir dire, okay, and jury selection. I'm sorry, my internet is a little unstable as well, so I don't know if I'm going in and out or I sound perfect. Um, okay. So I wanted to talk about what is voir dire and also R. Kelly's jury questions, the questions that were asked to the jury. Now we all know that Miss Bonjean had an issue with some of the jurors and the responses that they gave to the questions that were asked. So I have my girl Noonie. She's going to be reading with me the jury questionnaire. And we're going to go through that a little bit towards the end of the live because right now I'm going to present to you guys two videos in the moment. And it's going to talk about what the process is of voir dire. And then we're actually going to watch a mock trial. Well, not a mock trial, but a mock jury process. Give me 1 second. Sorry about that, guys. I apologize. Hey, Tears. What's up, mama? Do you guys hear me now? And thank you, Mountain of Inspiration. I love going to your videos and getting a little inspiration to get perked up for the day. Please, if you are not subscribed to the channel, anyone on this platform right now who is a content creator, who has a YouTube channel, please drop your YouTube channel in the link. Thank you. Thank you. And if any of yous who are content creators, drop the link, as well as those who have businesses. If you're a business owner and you have a website, drop your website in the chat. Please, everybody, support each other. Okay, we got to support our Black and brown businesses, right? No, that's fine, sweetheart. I don't know if you're a girl or a boy. Theory, I don't know if you are, but that's no problem, honey. I get it. You're new. You want to know what's going on. I understand. My sisters in the chat understand as well. Don't worry. Over here, we do get a little bit, we're a little bit on the eggshell side, because over here we have a lot of people come in. We have trolls that come in and they attack us because we're not for R. Kelly. So please just understand, my girls might seem a little on edge, and question people that come in. But it's because they protect the chat and they protect my channel, they protect us, and we protect each other. So thank you for coming, sweetheart, and welcome once again. Yes, happy birthday. That's right. Happy birthday to my peoples, my Pisces babies. Happy birthday to you all. Fantasia, happy birthday, sweetheart. Yesterday was Fantasia's birthday. Today is Key's birthday. Miss Keys, if she's still in here, I don't know if she's in here, but it was her birthday today as well. She's also a content creator. She does cooking. And her channel's about cooking. So if you guys get a chance to hang out with Miss Keys, if she jumps in the chat, hey T-Bam. If she jumps into the chat, say happy birthday. Today's her birthday as well. So we got a lot of birthdays today. Tomorrow's my birthday. Tomorrow's my son's birthday. Tomorrow's Wing's birthday. So, oh yes, Theory, yes. Welcome to OCOV over here. We are our family, our team. We call ourselves OCOV, which stands for One Color, One Voice. Because in this sector of the R. Kelly sector, in this group particularly, we are a mixed group. So we have victims, we have no victims, we have black and brown, white and yellow. And over here, we are one color, we are one voice. We don't care about black, white, yellow, orange, green, purple. We are one color, we are one voice. And our voices are for the victims and survivors of domestic violence and child abuse. So that's what we represent over here. So like I said, baby, welcome to OCOV and welcome to the Diva Divine Light Show. And Nooney's birthday is the 16th. Yes. Yes. So all my Pisces ladies, y'all gotta let me know when y'all birthdays is coming up. Email me, text me, let me know. I could throw little parties, y'all. Yes, celebrating Women's Month and March Madness. So enough that. We've been in for 17 minutes. This is going to be a long live, guys. Okay, because the videos that I'm presenting, one is an hour and like 10 minutes long. The other one is like 20 minutes long. And then I've got 26 pages to read with Noonie. So yeah, we're going to be busy today. All right. Yes. And her baby shower. That's right. And we're going to have a virtual baby shower. Noonie's expecting her baby in May. So in April, I would like to throw her a baby shower. Thank you, Mom. My mom's in the chat, guys. Say hello to my mom, Blanca. Thank you, Mama. All right, and Tears. Oh, honey, happy birthday to you too, Mama. Happy birthday to all my Pisces babies. Yes, so we got a lot of good things going on. That's what's up, y'all. Lovely's fair. What's up, baby boy? Now I know you're a boy, you're not a girl. I apologize for all this time calling you mamita when you were really a papito. So what's up, papito? All right. So, I wanted to explain what voir dire is. Okay. Now, voir dire, which I spelled it wrong. I'm gonna have to change it because it's VOIR. I put an E. There is no E after the R in voir. So voir dire is a French word, and it is the process by which potential jurors are chosen from a pre-scheduled, pre-selected jury pool. And during this phase of the jury selection, the attorneys for each party, the prosecutors and the defendants, as well as the judge, they ask questions of each potential juror to determine whether he or she has any bias regarding the case or other reasons he or she should not be chosen. So, voir dire, the French term, literally means to speak the truth. So, voir dire in French means to speak the truth. So, that's what this process is about, to speak the truth. And guys, part of my speech, if I might be a little sound a little slurry and stuff, but I just had my tooth removed yesterday, so I got a gap there, so it's kind of funny talking. It's the back tooth. Um so as I said, it means to speak the truth. So we want people to speak the truth. So when they do the jury selection, the process is so that they can speak the truth of what they feel, what they understand, and if they can be a person who is impartial and fair. So they want you to tell the truth about certain things, experiences. If you've ever been through, had an experience of a crime being committed against you, or if you um, have experienced other types of scenarios that happen within the case, or if you know the lawyers, or if you actually know the people that are in court with each other. If you know the plaintiff, or if you know the defendant, if you know the lawyers, the judge, they ask you those types of questions. Now, in this process, they do pick out people that are going to be for the defense and not for the defense. They also going to pick out people who are for the prosecution and not for the prosecution. But when they do that, they have to make sure that these people are also fair and impartial. Just because they might have had an experience, that doesn't necessarily mean that they won't be fair or impartial. Or just because they might have heard about, like, say, for instance, with R. Kelly, his scenario, it's a high profile case. So, being that it's a high profile case, if you know of R. Kelly and his music, and you've heard through media or the news reports, paper, that, or the internet, about R. Kelly's case, it's okay if you did. That's part of the process. They do keep some of them in. even if they knew about the documentary. It's okay. You guys are gonna understand what I'm saying once you guys check out these little videos that I'm going to present to you now. This first video is about 28 minutes long, and it speaks about the art of voir dire. So here he's kind of gonna break it down to you as to the process and how it goes, and what's said, what kind of questions, and how they kind of go about picking the jurors. Okay, and then we will watch the mock voir dire process. Okay, and then we will get into the reading of the actual questions that were asked of the jurors in the Eastern District of New York trial for R. Kelly. Okay. In the meantime, what I'm going to do while we're doing the videos, I'm going to go through the chat and put your questions or comments up on the screen as they are pertaining to what you guys are watching. Okay. So now let me share my screen. Thank you, thank you, thank you for the donations. Thank you, Mama. My mama loves me so. I love you too, Mama. Right, guys. Before I start this video, just want to make a disclaimer that I do not own the content of this said video here that's being played on the screen. This is for education purposes only. So the copyright laws of the United States recognize a fair use of copyright content. Section 107 of the U.S. Copyrighted Act states that notwithstanding the provisions of sections 106 and 106A, the fair use of a copyrighted work includes such use by reproduction and copies or phone records, or by any other means specified by that section. So this is for the purpose such as criticism, comment, news reporting, teaching, including multiple copies for classroom use, scholarships, or research, and is not an infringement of copyright. And this video and our YouTube channel, Diva Divine Light, in general may contain copyrighted works that were not specifically authorized to be used by the copyrighted holder, but which we believe in good faith are protected by federal law and the fair use doctrine for one or more of the reasons noted above. So if you have any specific concerns about this video or my position on the fair use defense, you can contact me at diva.josh.32332@gmail.com so we can discuss amicably the issue, and thank you very much.
What in the world are you supposed to do with jury selection? How in the world do you get a handle on the complex set of skills that are important for talking and selecting jurors that'll be right for the State versus Mitchell case. Well, let me give you some tips and some suggestions about ways to think about what it is that you're doing. And so let me talk about, first of all, the purpose of jury selection and talk to you about some theories that are out there about, give you some specific skills that I hope you'll see different purposes into a set of tasks that you have to perform to do the jury selection exercise. Jury selection, of course, is called voir dire, jury voir dire. Voir dire is to speak the truth. And the idea is that jurors are supposed to be sworn to tell you the truth for the purpose of your trying to figure out whether they'll be fair jurors for the case. And so we'll talk in just a minute about how it is that you get started and how it is that you describe what it is that you're doing. But one way to think about your task is to say, how do I make sure that I've got jurors out there that don't have experiences in their lives that are going to make it very difficult for them to be able to hear the case that I'm presenting and to be able to hear the fairness, the fair thing to do because of biases or prejudices or experiences that they may have. Now, you know, in the old days, one of the ways that lawyers dealt with jurors and jury selection is that because they were so closely connected to the communities in which they worked, they would often have lunch with these jurors. They knew where they went to church. They knew where it is that they lived. They knew what organizations they belonged to. They knew how they thought about the world because literally the trial lawyers, part of the trial lawyer's expertise was to know the members of the community, know how it is that the community was reacting to various things. It was a small enough community that selecting jurors was an art based upon the expertise of a lawyer who knew the community and knew it very, very well. And the task for us as modern trial lawyers is much more difficult. Number one, we're getting into court many fewer times. But number two, our connection to our jurors, our closeness to our jurors, our knowledge of our jurors is much more difficult for us to be able to get into because our communities often are very much apart from each other. And so, you know, one question that we could ask is, as opposed to joining the country club and playing golf, should you be joining the bowling league, or should you be hanging out in places where your jurors are likely to come from for the purposes of really understanding how these jurors are going to see the world and to think? In the size of the communities that so many of us deal with, even then, knowing what these jurors think and how they feel and how they look at the world is a very uncertain process, even if you hang out with them, if you get to know the folks from the pool of jurors that your jurors are drawn from. So the purpose of the jury selection process is, in this impersonal world, how do you get to know about people's values? And how do you get to know about their experiences? Well, some have said that really you're not looking for fair jurors. What you're doing instead is basically you're looking for jurors who are for you, who already have experiences. You decide what those experiences would be that would make them predisposed to be for you. And a classic anecdote might make the point. You know, Dr. Kevorkian, Dr. Death, a number ago, was tried on 9 different occasions for attempted murder, for euthanasia, for a mercy killing is what he called it. And what we have is then a laboratory to try to look at what jurors are going to be sympathetic to a doctor who is not shy about the fact that he is helping someone end their lives by administering some kind of a painkiller which has an effect of ending their life because they choose to do it. And the story is told that early on in these cases, in a focus group setting, one of the focus group members raised her hand early and said, you know, when I hear about Dr. Kevorkian, I keep thinking about an old dog. And this old dog was a dog that was suffering, and, you know, we put it to sleep. And the question, it seems to me, we have to ask ourselves is, if we do this for animals, and we think it's humane for animals, isn't it also fair to ask the question of whether or not it's something that we do for human beings when they're suffering? Well, you might imagine that that story being told affected the trial lawyers for Dr. Kevorkian. And you know that in the first 8 cases, in the cases that he was not found guilty, the first question, or one of the first questions in jury selection, as reported by David Ball, one of the jury consultants in these cases, was a question to the jurors: have any of you had an animal, a dog, that you've ever had to put to sleep? And by drawing on that common experience, the argument is that that experience could predispose now jurors in hearing about a case that, you know, Dr. Kevorkian should not be guilty of murder for what it is that he's doing. So in that theory, that approach is to try to find that experience. Where would you find those experiences? Well, boy, this is a place where you've got to really brainstorm. You've got to think about creatively about focus groups and trying to find out whether there are formative experiences. Presumably, we know from the O.J. Simpson cases that there are experiences that people have that could make them very much against you. Remember, in the O.J. Simpson case, the theory was that the police officers were in a rush to judgment, that they were racist, and that they planted evidence. Well, if your experience in the Los Angeles community was that police officers did plant evidence, did lie, did convict individuals or help convict individuals because of their racial bias, then you can see that in that instance now, you're not looking for jurors who are for you, you're looking for jurors who are against you. And you're trying to find out, if you were on the prosecution's team, what jurors have those kinds of experiences. How do you feel about police officers? What's your experience been with police officers? And your jury selection would try to find out those experiences and try to find ways to exclude jurors if they had those experiences. Now, so theories are often directed at these 3 things: finding fair jurors, finding jurors for you, finding jurors against you. And you need to know that a whole lot of courts have decided that because the time it would take really to find out about these experiences is time the court's not willing to give, that the court either takes over the purpose of voir dire by telling the jury, we're looking for you to be fair, and you tell us if you don't think you can be fair. We don't have the time unless we've got some pre-trial work done that's made a presentation to the court that shows there are particular kinds of experiences that need to be watched out for that's going to create an unfair bias. That what we're left with, if a court gives voir dire, it's often giving voir dire on a very limited basis, and trial lawyers today feel like that most of their time then needs to be spent protecting themselves from experiences jurors may have, biases that they may have, prejudices that they may have, that would predispose the jury against them and against their case. And so race is a topic of conversation. Race is important for the purposes of trying to determine whether or not individuals are biased and whether or not, in fact, they have prejudices against people of particular races. Being not from this community, being an outsider, being somebody who has a education or a situation where they are predisposed against folks who have those kinds of qualifications, either for or against, is something that trial lawyers today tell us that they spend their time when they're given that limited opportunity. Now, for our purposes of discussion, we're going to assume a wide open open voir dire. And for our purposes of discussion, we're going to assume that you are in a situation where you have a huge panel of folks and you're going to try to bring them into the box and you're going to try to create an environment where they're going to talk to you and they're going to share with you how they feel about the world, about the values that they have that help them either see this case or another. And we're going to allow you to go ahead and have conversations with jurors to do that. If you're restricted in that regard and you want to have that access, you're going to have to petition the court. Without that kind of permission granted, often courts will take over the process themselves. Maybe at the most, they'll let you submit individual questions. But you may find that most courts today have restricted your jury selection down, way down. We're going to do it in a broad way because we want to give you an experience of what it would be like to your situation where it's wide open and you get a chance to really explore the interests and biases and experiences that jurors may have. Well, what if you found a bias? What if you found a concern that would make you worry that the person might be against you? You need to know about two things. You need to
Do you hear me now? I was answering Truth Warrior's question. Do you guys hear me? Do you guys hear me? Please tell me you hear me. Oh my God, my internet's been acting up. Yes, okay, good. I was answering, I'm sorry about that pause. It's because I paused the video and then I answered Truth Strong's question. So if you guys didn't hear me, I'm sorry. I apologize. Let me start over. I am having issues with my internet, guys. So this might be a little choppy. Please forgive me. Truth Strong, you had said, so how many questions and jurors is Bone Jean talking about? I believe she was talking, I read the motion that she had put in. It was about 22 pages. And in there, she spoke about the jurors. She specifically called out a couple of jurors. And the thing is that they asked the question, do you know about the case with R. Kelly? Have you heard of the case in the media, in the news, social media, so forth, so forth? Have you heard about it, period, anywhere? And some of the jurors were like, yes. And some of them were like, well, one of them was like, yes, I heard about it. He's like Jeffrey Epstein. Another one was like, yeah, I heard about it. He likes young girls. I know he likes young girls, or I think he likes young girls, or I heard he likes young girls, something like that. And then they had another one had responded and said, yeah, well, I don't know. I think I can be fair. So she's questioning those jurors and their responses to the fact that they know of R. Kelly's experience and what he's going through. So she feels like those particular jurors should have been ejected for I forgot what it's called, like just cause or something like that, something cause, right? Or just cause, for cause, period. That's what they should have been ejected for. So let's continue. I'm going to rewind the video a little bit.
Being not from this community, being an outsider, being somebody who has a education or a situation where they are predisposed against folks who have those kinds of qualifications, either for or against, is something that trial lawyers today tell us that they spend their time when they're given that limited opportunity. Now, for our purposes of discussion, we're going to assume a wide open voir dire. And for our purposes of discussion, we're going to assume that you are in a situation where you have a huge panel of folks and you're going to try to bring them in the box and you're going to try to create an environment where they're going to talk to you and they're going to share with you how they feel about the world, about the values that they have that help them either see this case one way or another. And we're going to allow you to go ahead and have conversations with jurors to do that. If you're restricted in that regard and you want to have that access, you're going to have to petition the court. Without that kind of permission granted, often courts will take over the process themselves. Maybe at the most they'll let you submit individual questions, but you may find that most courts today have restricted your jury selection down, way down. We're going to do it in a broad way because we want to give you an experience of what it would be like to voir dire in a situation where it's wide open and you get a chance to really explore the interests and biases and experiences that jurors may have. Well, what if you found a bias? What if you found a concern that would make you worry that the person might be against you? You need to know about two things. You need to know about peremptory challenges. In every jurisdiction, you're given a certain number of peremptory challenges. The peremptory challenges are often somewhere in the neighborhood of 6 to 10, and they'll give you a chance to go ahead and excuse jurors for the purpose of saying that, well, I just don't feel good about this person. And I would rather not have my client have to deal with that person. They're just not feeling right to me. Your peremptory challenges are on your choice, based upon feelings that you get. Often those can be informed by a psychologist who can be sitting, watching as this thing goes on, or they can be informed by an associate who's taking notes as you're having conversations. You'll see that one of the most difficult things that happens as a skill of jury selection is how do you keep track of what answers you're getting from what people, and then how do you make a good reasoned judgment about whether you ought to exercise a peremptory challenge or not. Now, the other kind of challenge is a challenge for cause. The challenge for cause is brought about when the jurors, in a sense, admit that it'd be very difficult for them to be fair. And we'll talk about the different skills that you're looking when you want your opponent to at least exercise a peremptory challenge. And we'll talk about the skills of questioning that are involved when you're trying to lead a juror to a position where you would rather that they, in fact, admit that they would not be fair in a case. So, the purpose of jury selection is fair jurors, but when time is short, at least to try to get rid of jurors that are predisposed against you. And you're doing that by having conversations with folks that would allow you to exercise a educated judgment, to exercise a peremptory challenge. Force each side to use up their peremptory challenges so that, in fact, they're left with jurors that presumably, after that, each side has exercised their peremptories to a balanced jury. And also to make sure that if you can, you don't want to waste your peremptory challenges, you have an unlimited number of challenges for cause based upon a juror's admitting what it is that's going on. All right, now let's talk about the skills. Now, the first thing is getting started. Now, here again, the judge will have done a fair amount of the work in the typical setting. The judge will have asked the juror whether they know any of the parties. They'll have asked whether they know any of the lawyers in the case, whether they'll know any of the important witnesses that are going to testify, or any of the witnesses at all. And so there will be this, do you know any of these parties? Presumably, if you know these individuals, they could be a reason to keep you off. After that, the judge often will let counsel, if they've given them permission, to go ahead and address the jury.
Truth Strong, she asks, doesn't the defense get more jury picks than the government? They get to pick even amount. So it's one for you, one for me, one for you, one for me, one for you, one for me, one for you, one for me. And then they have the alternates. That's how they do it.
Jury to go ahead and stand around and address the jury. And what you'll have to see is that how the lawyers in the case, whether they'll know any of the important witnesses that are going to testify or any at all, And so there will be this, do you know any of these parties? Presumably, if you know these individuals, they could be a reason to keep you off. After that, the judge often will let counsel, if they've given them permission to go ahead and address the jury, to go ahead and stand around and address the jury. And what you'll have to see is that how the judge sets up the voir dire often can vary. Sometimes what you have is you have a courtroom that has about 40 jurors in it. You seat 12, you talk to the 12. As folks get excused, then other people come and they fill their places until the peremptories have been used up and everybody is satisfied. Or, in addition, what you can have is you can have a situation where everybody is sitting in one place and you're having a conversation to the group, to the large group as a whole, and you're trying to include prospective folks into the conversation one at a time. Sometimes the way it works is you have a voir dire on an individual juror, and you satisfy each side about that, and then you move on to the next one. That technique is a very, very labor process, and there's a whole lot of concern about whether everybody else is bored by your individual conversations with the jurors, and therefore often that is not a technique that you see.
T-Bam, she asks, can the judge dismiss jurors? Yes, the judge can dismiss jurors. Yes, the judge can dismiss jurors. They sure can. When you guys check out the mock jury selection, the voir dire in action, you will see that, yes, the judge will excuse a couple of the jurors. Wait until you guys see it in action. It's really cool.
Too much, but you could have an individual jury voir dire person by person, and you satisfy each side. Can have a situation where everybody is sitting in one place and you're having a conversation to the group, to the large group as a whole, and you're trying to include prospective folks into the conversation one at a time. Sometimes the way it works is you have a voir dire on an individual juror, and you satisfy each side about that, and then you move on to the next one. That technique is a very, very labor process, and there's a whole lot of concern about whether everybody else is bored by your individual conversations with the jurors, and therefore often that is not a technique that you see too much, but you could have an individual jury voir dire person by person. When you stand then, if you assume the usual process, which is that you have a group of folks sitting in the box and then a group of people who are sitting out in the audience, and you're going to ask questions to them, you should explain what jury voir dire is and tell them, in a sense, this is the time to talk to you, to find out whether or not you're the right jurors for this case. Now, it's important for them not to see that you're casting moral judgment on them if you excuse them. It's just that, and you could give them examples about this, that in fact, if you've just been through a divorce, maybe you're not the right person to sit on a divorce case. That if you've just lost a loved one, then maybe you're not in a position to be the best person in a wrongful death case. If you've just had a problem with a police officer and a false arrest, then you probably wouldn't be the right person to sit in a case where the police's judgment in arresting a person is at issue. And so the description of and giving examples of the kinds of experiences jurors may have in a kind of a generic case is a way that often that lawyers will get started with the voir dire. And you're trying to establish good eye contact with the people in the voir dire. You should take a pace that's open and friendly, that's conversational. And what you're trying to do is to say to them, we're looking for fairness. We want you to, in a sense, put yourself into the shoes of my client and ask yourself, this is the overall purpose. Could I be fair to him, or am I predisposed, based on who I am, to really not be fair to that individual based upon their characteristics. And that's where you're headed in this, and your opening conversation then describes what jury selection is. Now, one of the things that's interesting about jury selection is that you want people to open up. And obviously the best way to get them to open up is to ask them open-ended questions. Tell me about yourself. Tell me about your job. Describe to me where you work. Tell me what it is that you do day to day. Open-ended questions with jurors are ways to get them to talk. The problem is that as you're getting them comfortable and having a conversation with them, one of the things that you've got to be careful about is that everybody gets included fairly quickly. Otherwise, what will happen is that there is a potential for boredom to set in, or people feel excluded. You're very interested in having this conversation with this one juror, and you're less interested in them, and they feel slighted. And so very quickly, what you want to do is, by asking open-ended questions, is to engage the group in a whole. Now, where time is limited, after you do some beginning kinds of tell me about yourself questions, if the court gives you that, then you want to move very quickly into kinds of questions which are trying to get at those experiences again that may occur to jurors that would make them predisposed against you. Now, do you see the dilemma here? The dilemma is that if you ask a question like, have you ever had an experience with a police officer, or somebody you know had an experience with a police officer where you believe the police officer was not playing fair? If you ask a question like that, then the potential is that the rest of the jury veneer gets polluted by the answer that is given. That the argument that is, be careful, the pollution argument is to be careful about the kinds of questions that you're asking and the amount of discussion that you're getting from the jurors, because in fact it may affect the rest of the jurors to see the case that way. Now, you're going to hear different advice about this. Frankly, I think that the advice of against pollution is overstated. It does seem to me that all the jurors, as they listen to it, what you do is you develop that experience, the person is asked questions about, it sounds to me like that experience is very fresh to you, that it'd be very difficult to put that experience aside. You agree with me that it would be difficult for you to judge this case based on the facts presented in the case without importing in your own experience into the setting. That in that situation, that if the person agrees with you about that and they're excused for cause, that there's an education that occurs to the jurors that overrides the pollution, the potential pollution effect. On the other hand, there are, of course, situations where if a person is describing spouse abuse, or if a person is describing a very tragic situation, where there will be sympathy. And of course, exercise your judgment as to whether or not, in fact, you might want to talk about it in private. One of the things you should know is that you can choose, if you see that the juror is having difficulty, to say, would you like to talk about this in private? And to invite that as a way of understanding more about the experience, perhaps making a judgment about challenge for cause without having this overall pollution effect on the jurors. My view, for what it's worth, is that better to find out about that experience, to find out how deeply it's held, and not worry so much about the effect on the rest, if what you can do is to show by your questioning that, in fact, it's not fair for that person to be sitting on the juror. Then the educational effect presumably overwhelms the pollution effect that might otherwise occur. And again, for what it's worth, also my view is that if you can get people to talk about race issues and prejudice issues, that in fact, the education effect of getting people to recognize that it's difficult for them to be fair with those kinds of attitudes and views will teach the rest of the jurors as to how it is that they should behave, and that the pollution effect is overblown. Better to find out about it as opposed to not find out about it. Now, how do you find out about questions of race? Obviously, talking about attitudes towards busing, about where their kids go to school, can give you some general feel. When you have a race issue, when you have a defendant that you're representing that is a minority member of a community, and you want and worry about the race issues, one of the things to do is to really get some consultation and some help. You want to find out how do people feel. You want to find out what kinds of questions will give the most socially acceptable way into people talking about their attitudes and their perceptions. And that is something that involves good expertise of people that are out there that'll help you with that. But part of what you're doing is asking them to describe their experiences, to go deep, to tell you more about those experiences, and then make a judgment about whether or not you want to take it to a challenge to cause, or whether you want to stop the conversation and at least take them into a peremptory challenge and have them excused. So you have group conversations. You're asking open-ended questions. You're following up to try to get more information and more detail. Once you get enough information, what you're wanting to do is to make the decision about whether or not you're going to take them to a peremptory challenge. Your view about peremptory challenges, when you want the opponent to waste one, you've heard an experience that the person has that's predisposed for you, one of the things that you can do is to lead in a way that rehabilitates that juror. And the way that you lead to rehabilitate the jury is to say, despite that experience, I'm sure you could still put that aside and try this case based upon the evidence that's presented in this case. Am I right? You could still be fair, don't you think, based upon hearing all the evidence in the case. And that technique, a leading question that leads them to a fairness position, will force your opponent to use a peremptory. Judges often jump in order to be able to rehabilitate a juror if the judge is in the room, because they want to move it along and they want you to exercise your peremptory so that you're back into a position where you're stuck with the jurors that are there. But you can use those same techniques when you try to put on the other side the option for exercising a peremptory challenge. If you want to lead somebody to a challenge for cause, similarly, your open-ended questions will change and we'll move into a leading question format. So having had that experience of having a sister who's been abused as a spouse, and you saw the tragedy that she went through, and I take it that that's an experience that still is fresh. It's one that still makes you angry. You still probably have some strong feelings, don't you, about the situation that your sister was forced to suffer through. And I would imagine it'd be hard to put those aside in judging this case and deciding whether or not, in fact, there was abuse that was going on in this case. And if you get yeses to those leading questions, then you're in a position to exercise a challenge for cause, to ask the juror to be excused. Now, there's a whole technique about when do you exercise the challenges for cause. Do you exercise them immediately? Do you save them up within the group and the panel? You need to ask the judge and the court as to how they're dealing with the questions of when do you exercise your peremptory challenges and when you exercise your challenges for cause. You can see that what this does is it creates a record-keeping nightmare for a single trial lawyer. To have in front of you a group of people, you're trying to keep their answers straight, you're trying to remember what their names are, if you get to know their names, or you're just referring to them by jurors 1, 2, 3, and 4, and then that changes. You've got occupations, you've got information about their likes and dislikes, and keeping that track of that is a record-keeping nightmare. You want to make sure you have note-taking materials in front of you with the box with jurors as they go in, for you to be able to take notes and scratch out if people are excused in order to be able to keep track of what's going on, or to ask an associate to help you in that record keeping. Often lawyers today, when the cases are significant enough that and the resources are there to go ahead and do it, you may have people in the room, psychologists who you're consulting with, to help you make the decisions. So the skills of jury selection are, frankly, making an opening presentation about what jury selection is. Number 2, its ability to ask open-ended questions, both of individuals, but to the group as a whole, that as you get information about your jurors that you want to follow up, to go deep, to get more detail, to find out more about those experiences. And then similarly then, to make a decision about peremptories or challenges for cause, or whether or not you believe the person is fair and whether or not you've got enough to feel confident that they're at least in the midway point with you and move on. One last word. Where do you get the information? Where do you get the topics to ask the jurors about your case, to find out the experiences they may have? Well, there's no substitute for you're looking at your case from the perspective of people in the community and thinking, what experiences might they have that could make them predisposed against my client? So issues of race, differences in class, experiences that people may have had that have strong emotional appeal could predispose them one way or the other. Differences in gender, education level, differences in ways that people see the world, people who are in basically a belief that they control their environment, and in fact things then that happen are somebody else's fault if they're controlling their environment, or people who really think that life is not very easily controlled. You will find that jurors consultants say there are basically two types of people in the world, and you've heard about this before, A types and B types, and the A types that are control freaks, they're the ones that you want if you're the prosecution, and they're the ones that you want if you're the defendant, because obviously then it's somebody else's fault if something bad happens, and you can control yourself. If you can control your environment, then it's likely that the plaintiff is contributorily negligent. And then there are the B types who worry much more that life happens to them, and they're more the kind of the stereotypical bleeding heart liberals who are overly sympathetic to the sad story of an individual and what it is that's happened to them. There are all kinds of theories and all kinds of stereotypes, and you want to canvas broadly, asking yourself basically, what are those experiences and what is the profile of the juror who would be predisposed against me, or what kinds of experiences may be in play that could predispose a juror for me, especially if we've got the resources to sort that out. And having an analysis of those key topics that you want to talk about, the techniques are group interviewing. So some ideas about skills: public presentation, open-ended questions, follow-ups, and then leading questions to exercise challenges for cause and peremptory challenges.
Okay, guys, you guys hear me? So you check that out. You see how the process is? They ask you personal questions about experiences in life. They ask you questions about what you think of the world. They try to withdraw your emotions and personal feelings towards certain subjects, things, and places and people, and so that they can get a um, feeling, an observation and a perception of who you are and how you can be a fair person, whether you've experienced bad things or good things with the certain subjects and topics that they decide to throw at you. So even though these jurors were picked and they said what they said, right? At the end of the day, they were asked more questions. So the other questions pertaining to the subject and certain topics and things like that the lawyers threw at them, maybe even the judge might have said, oh, okay, well, listen, by curiosity, juror number 3, you just said XYZ. So how do you feel exactly about that? Can you break that down for me so I can understand a little bit better about what you mean? and then the person will explain themselves, and then they'll go, oh, okay, um, that's fine. You know what I mean? And leave them in there. So they try to get to the root of how you truly feel and how you will truly be an honest and fair person, even though you went through these experiences, or somebody that went through this experience, or even if you know about the case. And no matter what, they always pick somebody for the prosecutor and somebody who's for the defense. It's got to be even. So, did you guys get a lot out of that video? Yeah, a lot of other questions. They ask a lot of questions. That's why I wanted to present to you guys as well the actual mock trial of a voir dire in process. Because I was actually thinking about doing some of the actual trials that have gone on now, but I wasn't sure about copyright purposes and stuff like that. So I don't want to get my video blocked because I'm using a news broadcast. You know what I mean? So yeah. And hello to all the ladies that walked up into the building. T Bam, Ton Bella, what's up, mama? Aisha, what's up, baby girl? Pita, my Pita. I saw her. She walked into the building, didn't she? Yeah, she did. What's up, Shorty Rara? What's up, Shorty? True Strong Warrior and everybody else. Yes. So I hope you guys can understand that process. I hope that um this gentleman that was just describing the process, I hope that he was able to, because I understood it. So the way he broke it down, I was like, this would be great for everyone to understand the process before we actually watch the mock trial. That's all right, Tom Bella. You could be late to the party. You could play the replay. It's so good, mamita. And let's see. So I'm going to Nuni, you still in the building, right, my love? Yes. Okay, mama. I sent you the link, right? I hope I did. I believe I did. I sent you the new link, right? Are you ready to jump on and we can go through this jury questions real quick? When you're ready, mommy, jump in. Okay. All right. So I'm going to now how do I do this? I think I gotta open it and then okay. Oh wait, I have to open it. Okay. I gotta go back. Wait, which one is it? It's this one here. Okay, this is the paperwork here. Um Okay, Nuni, I see you in the back, mama. Give me a second. Okay, where's my paperwork? Oh, here we go. Okay. Give me a sec, mama. I got you. Oh, where's my mouse? Uh-oh. Something happened with my mouse. My mouse got stuck, guys. Oh, shit. Uh-oh. Where's my mouse? Uh-oh. Wait, my mouse is missing, y'all. What happened here? I might have to change the battery. That might be it. Oh, snap. Give me a second, Nuni. I know you back there, mama. Hold on. Yeah, I think I gotta change my battery. Nuni, you hear me? Oh shit. Nuni, you hear me, mama? I think I hear your sound in the background, but I don't hear you. Speak to me, baby.
Your sound is all messed up.
Oh no. Hold on. All right. You hear me now? You hear me now, Nuni? Do I sound low to you? Does everybody hear me? Does everybody hear Nuni? Oh my goodness gracious. Okay. Do you guys hear me? Okay, both are clear in the chat. Okay. You guys hear me? Nuni, speak, baby. All right, so you hear me. All right. Nuni, speak in the chat. Mama, speak. Okay, she's probably having issues hearing me. All right, so yeah. All right, let's let her come back. Sorry, guys, I'm having difficulties with my internet today. I don't know what is going on. Let me get my girl Nuni back here. Nuni, come back. Okay, baby. All right, here we go. Hello, baby. Do you hear me now?
Yeah, it was really bad. I thought it was you.
Okay, so now you hear me.
hmm
I don't know why am I hearing you in. Okay, hold on. Nuni, speak to me again.
Hello?
Yeah. Okay. I don't know why I don't hear you in my headphones now. That's weird. Oh God. But I hear you out of the speaker. It's
Okay.
strange. Okay, so all right, so I'm gonna go to. Let me go to the pages so I could. So I'm gonna go off screen, guys. But I'm gonna see the chat through the phone.
Okay.
Okay. All right. Let me make this a little wider. All right. Mm, 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 mm. Okay. Can you guys see the screen?
Yes.
All right. Perfect. Jesus Lord, I'm having one of those days. What is good? Ay, ay, ay.
Mm.
Seriously. Turn it to hey. Like I hate having interruptions and discombobulations with my lives.
Were
Please
you able
forgive
to
me,
hear me,
guys.
Diva?
Yes, I hear you,
Okay.
honey.
Okay, good.
I hear you. All right. So, as we know, this is the United States District Court, Eastern District of New York, the United States versus America, the United States of America versus Robert Sylvester Kelly, also known as R. Kelly. Now, this page is the questionnaire cover sheet. Okay. And here is the questionnaires. It says that the answers to the questions on this page will be disclosed only to the appropriate court personnel as directed by the presiding judge. So what they want to know, the first thing they got to put down, the jurors have to put down their names, their addresses, phone numbers, job title, the department where they work, the business address, the cell phone number, and then they have to sign it, right? Next thing is the confidential juror questionnaire instructions. So then they give you the instructions, and it says, to the prospective juror, welcome to the courthouse, and thank you for participating in jury services. This questionnaire is an important part of the jury selection process. You are sworn to give complete and truthful answers under penalties of perjury to the questions that follow. All of the information you provide will be kept confidential and will be seen only by the judge, the clerk's office, and the members of the prosecution and defense teams. Citizens in our community hold a wide variety of views and have had different life experiences that inform their feelings and views on different topics. We are generally interested in learning your views and feelings on a variety of issues and questions. There are no right or wrong answers to these questions. Just be candid and truthful. Voir dire, to speak the truth, guys, right? Then it says, please answer each question by placing a check next to the correct response and by providing the information requested. Please take your time and answer each question as fully as possible. Answer all questions. If a question does not apply to you, fill in the space with an N/A for not applicable. Do not leave any answer blank. Write in dark ink and as legible as possible. Please do not write on the back of any pages. If you need extra space, you may continue your answer in the space provided at the end of the questionnaire. On the remaining pages of the questionnaire, please do not provide any specific names or addresses or any information that may identify you or members of your family. It is a common practice followed in many cases in federal court, especially where the of the jurors in confidence. This in no way usual. This is in no way unusual. The court directs you not to discuss this questionnaire or your answers with friends, family, co-workers, court personnel, or anyone else. It is important that the answers you provide are yours. Point forward, the court further directs you not to read, watch, or listen to any news about this case, including all media sources such as TV, radio, newspaper, online sites, blogs, social media, YouTube, Google searches, etc. You are to discuss this case with anyone. You are not to discuss this case with anyone, including your family. You may not research this case or the people involved. Do not research any of the facts presented in this questionnaire. Any prior court proceedings, the victims, the defendant, the lawyers, and or the judge through any resources including the internet, media publications, or any other source of information. Jury service is one of the most important duties a citizen can be called on to perform. You will be fulfilling your civic duty by responding completely and honestly during jury selection. Your participation and cooperation in this process is greatly appreciated. And it says the Honorable Ann M. Donnelly, United States District Court Judge. All right, Noonie, you want to take it away over here on this next page, Mama?
Okay. And which page is that one?
This one is page 4.
Okay.
Well, actually,
4?
it's page 3. Page 3. Because over here it says page 4, but that's because they included the cover sheet. So it's actually page 3,
Okay.
where it says United States versus Robert Sylvester Kelly, jury questionnaire.
Okay. So start reading all that. Okay.
Yeah.
The jury questionnaire. This questionnaire is designed to help simplify and expedite the jury selection process. You must give true and complete answers to all questions. Although some of the questions may appear to be of personal nature, please understand these questions will help the parties and the court select a fair and impartial jury. Part of the selection process depends on your ability and promise to follow the law as it is explained by the court. Thus, some of the questions include descriptions of legal principles and ask whether you can consistently follow them. The defendant, Robert Sylvester Kelly, is charged with racketeering in violation of Title 18 United States Code, Selections 1962C and 1963, for his alleged role as a leader of an enterprise, the quote-unquote enterprise, and is alleged to have engaged in racketeering acts including bribery, sexual exploitation of a child, kidnapping, transportation of minors, and other individuals for purpose of engaging in illegal sexual activity, illegal coercion and enticement of individuals, and forced labor. Mr. Kelly is also charged with violations of the Mann Act, including the transportation of individuals, including of a minor, for the purpose of engaging in illegal sexual activity and illegal coercion and enticement of individuals, including a minor in violation of Title 18 United States Code Selections 2421A, 2422A, and B, and 2423A. Mr. Kelly has pleaded not guilty to all of the charges. It is the government's burden to prove Mr. Kelly guilty beyond a reasonable doubt with respect to each charge. This is just a summary of the charges to give you some background of the case. The court will instruct the jury as to elements of the crime charged and the applicable law at a more appropriate time during the trial.
Now, thank you, Mama. Now, remember what I was talking about the other day when we were the other day we were talking about codes. And as you can see, what he's charged. Let me open it up. Let me go back. So now we didn't get to talk about 1962C or 1963. That has to do with the racketeering. What we did about was 2421A, 2422A, and B, and 2423A, which was the coercion, the transportation, and all had to do with minors. On this part, we want to know about the jurors' background information. They want to know what their current age is, if they're male or female, non-binary or other. Also, where do you currently live? How long you lived there? Where did you live before that? How long did you live there? Where were you born? Where were you raised? Where else have you lived? And it says, please, and foreign countries. Also want to know, do you own or rent your home? They want to know if you're employed full-time, part-time, such and such, homemaker, student, unemployed, looking for work, disabled. They want to know if you are currently a student and what area you study. And if you're employed, describe your occupation and your duties. Then they also want to know, what other kind of jobs have you held throughout your life? Next one over here, they want to know how far did you go in school? If you attended college or graduated school, what did you study other than English? What languages did you speak? Would others describe you as an open-minded and willing to listen to and assess different viewpoints? Have you attended any concerts within the past 10 years? And then it says, please state which group or performance you saw, where, and approximately when. They also want to know, have you ever served in any branch of the armed forces? National Guard, and what branch? And what was your rank? Have you or any close family members employed or owned a business? Noonie, take it away on page 6.
Okay. Let me see.
Should be number 23, Mama.
The question. Okay.
Yeah, question 23.
What special skills, hobbies, and or interests do you have, including foreign travel or membership in any clubs, groups, or organizations?
Breaking up a little bit, Mama.
Can you hear me?
Noonie, you were breaking up a little bit. Yeah, you were breaking up a little bit.
Am I still breaking up?
Yeah, you're okay in the moment. Go ahead.
Okay. What special skills, hobbies, and or interests do you have, including foreign travel or membership in any clubs, groups, or organizations, including civic, social, union, professional, fraternal, recreational, volunteer, or religious? And 24 says, are you currently a member of any church, synagogue, mosque, temple, or do you participate in any other religious organization? Mark yes or no. Do you or have you held any leadership positions in any such church, synagogue, mosque, temple? If yes, briefly describe such positions. Question 25, do your religious beliefs affect your ability to sit in judgment of others? Yes or no? Question 25. What is your current relationship status and how long have you had the status? Question 25. Please describe your spouse?
27.
Oh my God. Oh my God. Question 27. Please describe your spouse's, partner's, significant others, occupation, job duties, and highest level of education. Please
Now
do not.
you see how they're asking, they want to know your religion, they want to know your personal life with your relationship, they want to know your work, they want to know a lot.
Mm-hmm.
They talk about, do you have any children? They even want to know the gender, the age, the highest level of education, the type, like,
Wow.
they get deep. They get deep. Go ahead, mommy.
Where do you want me to go?
Page 7.
Okay, let's see. Knowledge of the case and people. There have been media reports about this case. We are interested in what you have heard or read, if anything. Question 29. The case for which you are summoned involves the defendant, Robert Sylvester Kelly, also known as R. Kelly. Have you read, seen, or heard anything about the case, the alleged crimes, or people involved? Mark yes or no, or sounds familiar but unsure. But if yes, please describe in detail what you recall reading, seeing, hearing about the defendant, the alleged crimes, the court proceedings, or the people involved, regardless of whether you believe this information is accurate or not. If you need additional space, please use the additional comment page at the end of this document.
All right, so I believe that this question here, all right, is one of those questions that Ms. Bongine was looking at and what they said, right?
Mm-hmm.
We will go to the man, I gotta see where it's at though. I couldn't find it. I gotta go back to it. In the process, in a couple of minutes as we're going along, I'm gonna go back into Bonjean's her motion for a new trial. I believe that's where it was. I believe that was the 22-page motion. So this question here might be one of the questions where she got her response from she put in the motion. All right. The next one, Nuni.
Question 30.
Yeah.
Have you read, seen, or heard about Robert Kelly, also known as R. Kelly? Yes or no, or unsure? If yes, please describe in detail what you recall reading, seeing, or hearing about Robert Kelly, also known as R. Kelly, and your views or feelings about that information.
Okay.
31. Have you watched or heard any interviews of Robert Kelly or any TV shows featuring him or any special documentaries about him? Yes or no?
Right.
If
That
yes,
was definitely one of the questions.
Yeah.
Because she put that in the motion. This question here, I believe. Those 3 questions were in her motion. So let's continue. What is this? Page number 8. Page number 8, and she asks here, they ask, from what you have seen, read, or heard, do you have a general impression of the defendant? I believe that was one of the questions as well. Right? The next one here, 33, says, have you ever talked about or overheard discussions about any aspects of this case or discussed it online, for example, on social media? Yes or no? If unsure, yes, please describe what was said, including any options you expressed. Okay. Next one says, have you ever read or posted opinions online related to this case or the people involved? Yes or no? Okay. Did she speak upon, have you ever read or posted opinions? Yeah, I think she did speak I think she did talk about that too. And then number 35, have you ever posted opinions online about any court proceedings? Okay. 36 says the case involves allegations related to someone who is known publicly as a result of his profession in the music business. Is there anything about the fact that the defendant is a celebrity or public figure that would make it hard for you to be fair and impartial juror?
Mm-hmm.
So, depending on what they said here, because they let people in, the judge let them in, the lawyers let them in. All right, Nuni. Number 37, Mama.
Okay. The defendant is charged with leading an enterprise which is alleged to have engaged in conduct including bribery, kidnapping, sexual abuse, exploitation of a minor, transportation of minors and other individuals for the purpose of engaging in illegal sexual activity, production of child pornography, and forced labor. These are only charges. Mr. Kelly is presumed innocent of all these charges. Mr. Kelly has pleaded not guilty to all of the charges. It is the government's burden to prove Mr. Kelly guilty beyond a reasonable doubt with respect to each charge. Is there anything about the nature of these charges in and of themselves that would interfere with your ability to decide this case fairly and impartially in accordance with the instructions of the court? Yes or no?
Okay.
The law provides that individuals under certain ages cannot consent to sexual activity with other individuals. Is there any reason that you could not apply that to the law? Yes or no?
Mm-hmm. Good question.
And then question 39, the charges in the case involve allegations regarding exposure to one or more sexually transmitted diseases. Is there anything about such an allegation that you believe would affect your ability to serve as a fair or impartial juror? Yes or no?
Go ahead, Mama. You can read 41.
Okay. Experiences with and opinions about the criminal justice system. 41. Have you or a friend or family member ever been employed, trained, applied for, or volunteered in any law enforcement agency, corrections, or a related field? Police, such as police, sheriff, FBI, jail, probation officer, private security, etc. Yes for self, yes for a friend or family member, or no. If yes, without listing names of the persons, please indicate your relationship with that person, where the job or nature of experience, and approximate dates. Wow.
Wow. So they want to know, they really want to get deep. They want to know even if you have relatives that are in the force or, things of that nature. 42 says, have you or a friend or family member ever been employed by or volunteered in any aspect of criminal defense work, including any public defender's office, a legal aid, or with a related support or advocacy group having to do with the right of people charged with crimes? Yes for self, and then yes for friend or family member, and no. If yes, without listing names, please indicate what person, where, the job, or nature of experience, and the approximate dates. 43. Have you or a friend or family member ever been employed by or volunteered in any aspect of the work of a prosecutor's office, including any related support or advocacy group? Yes for self, yes for friend, no, and if yes, without listing names, indicate relationship and the job, nature, experience, location, okay, and dates. The next one here on 44. Go ahead, Nuni. I'm gonna go get something to drink.
Have you or a friend or family member ever been accused of charged with or convicted of any crime, or have been the subject of criminal investigation? Mark yes for self, or yes for friend or family member, or no. If yes, without listing names, please explain the nature of the charges and dates. and who brought the charges and the outcome. 45, have you or a friend or family member ever been accused of sexual harassment? Mark yes for self, yes for a friend or family member, or no. And if yes, without listing names, please explain the nature of the allegations, the approximate dates, and the outcome. 46, have you or a friend or family member ever been the victim of sexual harassment, sexual abuse, or sexual assault? Mark yes for self, yes for friend or family member, or mark no. If yes, without listing names, please explain. 47, have you ever been a victim of a violent crime, or do you know anyone who has been a victim of a violent crime? Mark yes for self, yes for friend or family member, or no. If yes, without listing names, please explain who the victim was, when and where the crime was occurred, what happened, whether you or your friend or family member received medical treatment as a result of the crime, whether anyone was arrested or convicted. If so, what the outcome of the case was, and what, if any, effect this experience has had on you.
Wow, right? I would have been crazy with these questions. Like, what? Because I mean, I've been to jury duty. I've been called, and you do the whole summons thing, and then you get a response of a date to go. You go, you get there, and you're waiting and waiting and waiting and waiting. The times that I went, all I did was just sit there and wait. I didn't even get picked to go into a courtroom to actually do a voir dire process. I was just sitting on the outside waiting, waiting, waiting. And I got paid for those 2 days for just sitting and waiting. At the time, it was $40 a day.
Oh, wow.
Yeah, $40 a day. I don't know what they pay now. I believe it's $50. I believe they pay you now $50. But the experience, I never got to actually have that experience to actually go and do a voir dire process. Have you?
No, I always try to get out of it. uh-uh.
Like everybody else in the United States of America.
Mm-hmm.
And you know that after a certain amount of excuses, you can't, if they're not medical excuses or something to that point, they're catching up with people these days and doing that,
Wow.
so
It's hard to make like self-employed people right now, so because like I'll be like, shoot.
you got to try it one day. I mean, you never know, the experience, might just enjoy the experience.
Yeah, I think I'm going to
I
next
say
time.
like this: go and do jury duty. Go do it. Get the experience. I mean, I understand it might be boring. It might be a case you're not really interested in, but do it for the experience. Just do it for the
Mhm.
experience. I mean, you do get paid. It's not like you don't. What are you getting paid?
Yeah.
$50 to just sit around? I mean, hey, it's something. You know what I mean? It's
Mhm.
extra cash you weren't expecting. And you're doing your civil duty as a citizen to the United States of America and helping out the justice system and being one of those peers that get to judge another peer and their case. Whether they're guilty or innocent, you got to look over it, check it out, find the evidence, look over the evidence, and go by the evidence. Where does the evidence lead you to? Where does it point to? What are the facts of the case? That's what you have to go by, regardless of how you feel about another person and what they went through or what you personally went through. You have to be the person to say to yourself, damn, I think I could be fair and impartial. Now, in all honesty, if I got a case like this for R. Kelly, I don't think I'd be able to do it. I'm too emotional. There's too much personal stuff within me that I don't think I would be a fair juror.
Mhm.
So I
Yeah.
would just let them know from the jump. Listen, yes, I did have an experience I was abused, and I don't think that I could be a fair juror because I never got to prosecute my abuser, and I think this would be triggering for me. And the judge would say, "Okay, juror number three, are you sure about this? Are you sure about that?" You know, they double check with you, and then you say yes or no. And if you say no, I can't be fair, then they say, okay, well, we have to excuse juror number four for cause and have a nice day. And you go your ass home.
Mhm.
So now, question 49 says that would that experience affect your ability to be fair and impartial in this case? Please explain. 50 says, have you ever been involved or do you expect to become involved in any legal action or dispute with a government agency? Or have you had any financial interest in such a dispute? If you answer yes to question 50, is there anything about the experience that would affect your ability to be fair and impartial juror in this case? Have you or has anyone you know ever been involved in providing government with information in a criminal investigation? Yes or no? If yes, without listing names, please explain the circumstances and who was involved. Then 53 says, have you ever or a close friend or family member ever detained in a prison jail before? Yes or no? Was it a family member or was it yourself? And if yes, you have to list the person and explain. You want to read number 54, Mama, and on for a
Yes.
couple?
Yes.
Okay, go
Hmm.
ahead. I'm going to go on
Have
mute.
you, okay. 54, have you ever taken any courses or worked in the fields of sexual abuse counseling, law, criminal justice, criminology, or other related areas? Yes or no? If yes, please explain and state whether you continue to take courses or work in that field. Have you ever known anyone, including yourself, who was the victim of sexual assault, other assault, homicide, or other act of violence that required medical treatment or counseling? Yes or no? If yes, please explain. 55. Anyone in your household or close friend own any guns? Yes or no? If yes, please state the relationship to that person. Um, don't list any names, but rather respond wife or friend. And what type of firearm. 57. Do you have any friends or family members who have ever been lawyers, judges, law clerks, or otherwise involved in the legal field? Yes or no? Without listing names, please explain the relationship, the nature of their work, and whether and how often do you communicate regarding their work. 58. Have you, a family member or close friend, ever practiced law in the area of criminal defense or prosecution? Yes for you, yes for a friend or family member, or no. If yes, please explain. 59. Do you have any opinions about lawyers that would affect your ability to be fair and impartial juror? Yes or no? And if yes, please explain. 60. Have you, a family member or close friend, ever filed a complaint with the police or any law enforcement agency against anyone? Yes or no? If yes, please describe the circumstances surrounding the complaints. 61. Have you or anyone close to you have had a positive or negative experience involving the police or any law enforcement agency? Mark yes or no. Yes, without listing names, please explain. 62. Do you or have you read any books, blogs, social media sites, or other websites about celebrities or crimes, including sexual abuse or assault, and or watch or listen to any television programs, movies, podcasts, or documentaries about celebrities or crimes, including sexual abuse and sexual assault, or the criminal justice system? Yes or no? If yes, please list them and state what impact, if any, have they had on you. 63. Have you ever served as a juror before? Yes or no? If yes, please list the number of civil cases or criminal cases. Have you ever served in the state court jury, or the federal court jury, or on a grand jury? Without listing names of any parties, in what type of cases have you served as a juror? Example, an auto accident or burglary? Sorry. Were you ever the foreperson? So mark yes or no. If yes, how many times? Did you ever reach a verdict? Mark yes or no. If no, what happened? 65, the law provides that a defendant in a criminal case is presumed innocent at all stages of the trial and is not required to put on any defense at all. The government is required to prove the defendant guilty beyond a reasonable doubt on each charge. Is there any reason why you could not apply that law? Yes or no? If yes, please explain. 66, the law provides that a defendant is in a criminal case has an absolute right to not testify, and a jury cannot hold it against the defendant if he chooses to not testify. Is there any reason why you could not apply that law? Yes or no? If yes, please explain. 67, do you believe the police or law enforcement officers have more likely to tell the truth than other witnesses? Mark yes or no. If yes, please explain. 68, do you believe the police or law enforcement officers are more likely to lie than other witnesses? Mark yes or no. And if yes, please explain your views. 69, the judge will instruct you that members of the law enforcement who testify at trial are not in and of themselves to be considered more or less truthful than witnesses who are not members of law enforcement. Regardless of your own opinions on that subject, will you be able to follow that instruction? Mark yes or no. If no, please explain. Are not in and of themselves.
I'll take over now.
So what is 69 saying, that it doesn't matter that they're law, that you don't have to take their word, or what is it saying?
Right. It says that the judge will instruct you that members of law enforcement who testify at trial are not in and of themselves to be considered more or less truthful than witnesses who are not members of law enforcement. Regardless of your own opinions on that subject, will you be able to follow that instruction? All right. That members of law enforcement who testify at trial are not in and of themselves to be considered more or less truthful than witnesses. Oh, so in other words, what they're trying to say, just because they're law enforcement,
Yeah.
doesn't make it so true that what they're saying is always true.
Yeah.
Just because they're police officers, it doesn't make them more or less honest people.
Yeah.
Right? Is that what that
Yeah.
means? What do you guys think?
Yeah,
in the
so
chat?
that's what I think. Yeah, I think
Right?
that they're saying that you shouldn't say that they're more or less truthful than the other
Than your
witnesses.
average person, right?
Yeah.
Than your average person. Yeah. Yep. Then in 70 says, if selected to serve as a juror, you will be instructed that Mr. Kelly and his counsel do not have an obligation to present any evidence at all at trial, including after the government rests its case. Do you accept this principle? And will you be able to apply it if selected to serve on this jury? Now, what, like, my thing is, it's crazy how the burden is on the government to prove his innocence or guilt, right? But why is it that it's not part of the defense to prove his innocence? I don't get it. Like, isn't that so weird? Like, don't you find that strange how that is? Like, You know what I mean? Like all you could do is just say, well, Your Honor, I think this person's a liar, that person's a liar, question the experts. You know, I guess, I don't know, because in the OJ trial, I don't know, it was a little more different, right?
Yeah.
Because you only had the government because the witnesses were dead, the actual victims, right? So
Hmm.
all you had was the other people around them that were around them in their relationship that knew of them to speak on behalf of the victims and behalf of what's his name? OJ. Now in the
Hmm.
OJ trial, I'm trying to think. Um, were there any witnesses for OJ?
I wouldn't say witnesses, but isn't the guy um well, actually, the little white guy that was his
Cato.
yeah, Cato, he was like saying he was trying to stick up for him to me it was trying to he was trying to prove his innocence. Why, you know,
Okay,
because I think
because
that
I
he got
remember in
coerced.
that trial, I remember in that trial that Cato also explained how he heard a dump and a noise, and that kind of threw everybody off in a sense, like, oh, because there was a theory that the person came from the back of the house, that the person came from the back of the house of the condo complex, came through the back entrance and jumped on the AC or bumped into the AC that was there under his window or something like that,
Yeah, the AC
right?
unit.
And then ran all the way to the front. And then once they approached Nicole and Ronald, that's when the situation escalated and happened. So, I don't know, like that case was crazy too. By
Hmm.
the way, at the end of this live, I'm going to leave you guys with a video that I found on YouTube about juror number 5 who was in the OJ Simpson trial. And she's going to talk about her experience. And it's an hour long video. And I think like you guys would enjoy it. I don't know if you guys are really interested in it, but if you are, stick around because she throws a lot of different and interesting points about what she experienced. And I thought that you guys would enjoy it too. I don't know, I'm kind of becoming this law buff. So, for those that are into the law, I guess you guys can stick around for that process of the video at the end of the live.
Hmm.
So, we're going to continue here. All right. So let's go. Number 71 says one or more government witnesses may testify that they participated in crimes. The witness may have a criminal history and may be testifying pursuant to a grant of immunity from prosecution or and hold on a second.
I need your Gmail.
Why?
I sent something to you,
Okay, hold on.
and it's for my Twitch account, so I can start becoming a Twitch streamer on my Xbox, so I can probably maybe make money.
No, okay. All right, baby. Do your
The
thing.
way I play in game as, I can probably pick a few people up.
T-Bam, if he doesn't present any evidence that will be on him, the jurors wouldn't have anything to debunk the government's evidence unless the defendant at a cross-examination was good to give reasonable doubt.
Yeah.
I think with all the accusations that they throw out there, that's why they have to kind of participate in the trial, because it's like, you look so bad, how could you not say anything?
Right. Exactly. It everything is a process. It's like when you do these things, it's like you go and you're on eggshells. You got to do shit right. You got to cross your T's, dot your I's. You got to have all your ducks in a row. You can't count your chickens before they hatch. Like, it's a lot of shit that goes on. It's a big thing.
Yeah.
I'm gonna do a live stream.
Okay, honey, enjoy your live stream. Don't start being crazy, okay? Okay. So, 72 says that it is the law that the testimony of a single witness, including a witness who has received immunity from prosecution, can be sufficient to convict the defendant of a charged crime. If the juror finds that the testimony of that witness established proof beyond a reasonable doubt, is there any reason why you could not apply this rule of law? Please explain.
Mm-hmm.
Under certain circumstances, the government can obtain authorization from a judge to search a premises or electronic media to obtain evidence, including but not limited to emails, text messages, video recordings, letters, financial information, and other materials or information. The judge will instruct you that any evidence that is presented to you at trial was obtained legally and you can consider it. Is there any reason why you could not follow this instruction? That's a good question. Shit, you damn right. I'm going by the evidence. Bring it on. Bring it.
Mm-mm.
Bring it on. Under the law, the facts are for the jury to determine, and the law is for the judge to determine. You are required to accept the law as the judge explains it to you, even if you do not like the law or disagree with it, and you must determine the facts according to those instructions. So, would you have any difficulty following the judge's instructions? Yes or no?
Oh, wow.
Under the law, the question of penalty, if any, should not enter your deliberations. Would you have any difficulty following this rule? 76. Under the law, emotions such as sympathy, bias, and prejudice must not enter into the deliberations of the jurors as to whether the guilt of the defendant has been proven beyond a reasonable doubt. Would you have any difficulties following this rule? Mommy, can you read number 77?
Yes, ma'am. Let me
My jaw is
see.
hurting me. I'm about to go take a pain med real quick.
Okay.
No, I don't hear you. I'm back.
Okay. I just did 79. So, and then my
Oh, no,
husband
we
called,
did
so
not hear
I
you, baby.
no?
No, we did not hear you.
Okay. Can you give me 1 second? Because my husband, I have to do something real quick.
Yeah, sure. Go ahead. Go
Okay.
ahead. I'll
Okay.
pause. I'll pause. I'll continue. I'll continue.
Okay.
Okay. Don't forget to go on mute. All right. Okay. So 77 says, do you have any views about people of other races or ethnicities that would affect your ability to be a fair or impartial juror? Now they want to know about the media and the internet. So now they're going to ask questions about the media and the internet and what you know, right? So I don't see what you guys are saying in the chat because I'm off screen, okay? My son did have my phone. Okay, he brought it back. Here we go. He did bring it back. Let me go back to my So 78 says, what publicly known person do you most admire and why? What publicly known person do you least admire and why? How often do you make it a point to follow the news? Every day, almost every day, several times a week, several times a month, or never? 81. Which sources do you regularly rely on for news? Please check the box. Corresponding: television, newspaper, radio, internet, social media, YouTube, podcasts, magazines, personal conversations, and other. 82. Please list the names of your regular news sources: social media, Facebook, Wall Street Journal, New York Times, New York Post, CNN, Fox News, Univision, etc. Those are examples of regular news sources. Now, what books, if any, have you read recently? What magazines, if any, do you read regularly or subscribe to? What is your favorite book and why? What are your favorite television shows? Who are your favorite music artists and groups? What are your favorite internet sites, vlogs, podcasts, or social media sites? 89 says, how often do you tweet, blog, vlog, podcast, or post comments on the internet? Every day, almost every day, several times a week, several times a month, or never? Do you have your own online blog, vlog, YouTube channel, or podcast, or do you contribute to any blog, vlog, YouTube channel, or podcast sites? Yes or no? And if yes, without listing names or identifying the blog, please explain the nature of the blog. Wow. They want to make sure that you are not the infamous Sylvia. They want to make sure you're not DJ. Listen. They want to make sure you're not Deboski. They want to make sure that you are not anyone from that side, especially those crazies that were after the lawyers and the judges and getting all involved. You know.
I'm back, hon.
All right, baby. Street hustling and screaming free R. Kelly. Yeah, no. All that wicked stuff. So number 91 says, do you know anything about the Me Too movement? Yes or no? I believe that was one of the questions, right?
Yeah.
Right? She had said something about the Me Too movement and that they had a comment on it or something. Let me highlight that question because I believe that was part of it. Okay. Have you supported or participated in the Me Too movement? If yes, please describe. Please generally describe, including any provided, events or protests attended, posts or blogs made responded to. All right. Nuni, you want to read or should I continue?
Yeah.
Okay. So go ahead, Mama. I'm on 93 here.
Okay. Okay, so if you are selected as a juror in this case, the judge will instruct you to avoid all media coverage and not to go to the internet with regard to this case for any purpose. That is, you will be forbidden from reading newspaper articles and watching news reports about this case, Googling this case, blogging, vlogging, tweeting, podcasting, and otherwise posting or commenting on social media sites, etc. Do you have any reservations or concern about your ability or willingness to follow this instruction? Yes or no? And if yes, please explain. Let's see. Is there anything about the nature of the charges or the facts of the case as they have been explained to you thus far that would affect your ability to serve as a juror in this case? Yes or no? And if yes, please explain. If you were selected to serve on this jury, would you consider and respect the views of the other jurors, even if their views are different from yours, in accordance with the court's instructions before making your decision? Yes or no? And please explain. If there is anything that you would like to discuss privately with the judge and juries, yes or no? Please review the list of names and organizations on the following pages and then answer this final question. Are you familiar with any of the individuals or organizations named on the list? Yes, no, or unsure. If yes or unsure, indicate who you know and or may know and how you or may be familiar with them. The names and organizations. Please review the following names. If you are familiar with any of the individuals of the or organizations, please click yes on the last question of the page and indicate there who you know and the nature of your relationship. Let's see. Scheduling and ability to serve. This proceeding is expected to begin on August 9th, 2021, and last approximately 4 weeks. Court sessions will last from approximately 9 a.m. until 5 p.m., Monday through Friday. There are regular breaks approximately every 90 minutes and a 1-hour break for lunch. Do you have any difficulty reading, understanding, or speaking English? If yes or no, and if so, please explain. Do you wish to apply to the court to be excused on the grounds that the jury service in this case would be a serious hardship to you? Yes or no? If yes, please describe your circumstances. Do you have any personal, family, or professional obligations that you feel would seriously interfere with your ability to focus and concentrate as a juror in this case? Yes or no, or unsure? If yes, please explain. Does your employer pay you for the time missed as the result of your jury service? Yes, no, or unsure? If you are unsure, please find out before you return to the court for a jury selection questioning. Do you have any condition, disability, or need that will require any special consideration or accommodation while you are in court? Yes, no. If yes, please explain. Do you have any difficulties not corrected by a hearing aid? Yes or no. Do you have any trouble seeing even with glasses? Yes or no?
Yes,
Are
I'm deaf and
you
I'm blind.
are you taking any medications regularly? Yes or no? Do you have any medications? No. Do any of these medications affect your memory or concentration? Yes or no? Is there
I
any
smoke
reason
weed.
why that affect your concentration?
It actually helps.
Yeah, tunnel vision. Is there any reason why you would be not willing to comply with the court instructions concerning social distancing, mask wearing, and other precautions related to the COVID-19 fake pandemic? Yes or no? Is there anything else not covered by this questionnaire that you believe is relevant to your ability to be fair and impartial that you would like the attorneys in court to know? Yes or no? If yes, please explain. And additional comment page. I think we're done. Boom.
Yes, ma'am. We are done with that. Yes, we are. So, stop sharing. So, those are the questions started picking people's names and bringing them to the front. So now we're going to check out a video of the actual voir dire process while I go searching and hunting for Miss Bonjean's motion. Okay. So
Mm-hmm.
I guess Nuni, you can go on mute or you can go back in the chat in the moment. It's up to
Okay.
you, baby. I'm not throwing you out, but I'm just giving you the option. And let me share my screen. Let's go back to that. You said you couldn't do that form. Like, that's a lot of questions.
Yeah,
It's
I
so
don't
personal,
know.
right?
Mm-hmm.
Hey, just 504 girl. What's up? What's up, Ty? What's up, Aisha? What's up, everybody that just walked up in the room? What's up, y'all? What's up, SK? What's up, lady? Yeah, so there's a lot of questions that they need to ask at first to find, to kind of give them an idea of what they're getting into. So they want to that's how they kind of pick the people from the mass and bring them into that courtroom. So now I'm going to play the actual mock trial. Well, not mock trial, mock voir dire process. All right. So let me share my screen, share audio. Um, is this it here? Wait, where is it? Hold on, let me find it. Ugh, I gotta refresh the page. Jesus Christ. My internet is being funny as hell today.
Mine too.
Ugh, it's ridiculous. I already had the video prepared and where it was and everything, and now I gotta refresh this shit all over again. Yes, honey, hold on. 1 second, my love. Oh, I'm so having internet issues. I apologize, guys, for this. This is a horrible day for me. Yeah, it really is. This is terrible. Between the interruptions and the internet interruptions, I'm
We
going
got
through it here.
kids and husbands.
Right. Like, what the hell is going on here? This is my
Mhm.
life, y'all. Hey, rocking with the truth. What's up, mama? Take is in here. I don't see her. Oh,
She
there she
just got
goes.
in here.
Hey, Take. What's up, mama? All right, here we go. Voir dire in action. All right. I found the video. Damn. And like I said, at the end of this, I'm going to take you guys out with just watching the juror number 5 for the O.J. Simpson trial. All right, let me pause it. Let's start the process. Okay. Take the sound off here. Okay, Nuni, I'm going to go on mute. Go on mute too, mama.
Okay.
All rise for town session. I'll let Rob Kirkland presiding. Good morning, you may be seated. Okay, we're on the record in the matter of State of Arkansas versus Cosmo Kramer, CR 2005-47-2. Stay ready for trial?
Yes, Your Honor, we are.
Okay. Defense?
Defense is ready, Your Honor.
Very well. Will the clerk call the roll?
Marquise Boston.
Here.
Andrea Pate. Here. Angela Smith. Here. Ryan Rainwater.
Here.
Teresa Barnett.
Here.
Jimmy Meyer.
Here.
Diane Lane.
Here.
Marcy Lawson.
Here.
Chris Dixon.
Here.
Lauren Brown.
Here.
Martha Cox.
Here.
Donna Holloway.
Here.
Brooke Little.
Here.
Patty Hill.
Here.
Jamie Raleigh.
Here.
Tiffany Gray.
Here.
Michelle Hill.
Here.
That's all your name.
Very well. Will you swear the panel?
Would the potential jurors please stand and raise your right hands? You and each of you do solemnly swear or affirm that you will true answers make to such questions as may be asked you, touching your qualifications to serve in the case now pending. So help you God.
I do.
Be seated.
Thank you, Madam Clerk. Will you please call 12 names?
Andrea Pate will be juror number 1.
As you're seated, please go to the far back row and seat 1, 2, 3 along the back row, and then come back and fill in the second row after when you get to the numbers 1, 2, 3, 4, 5, 6. That's good. Actually, we need to move the chair down to make it even. So, thanks, Mr. Bailiff, if you don't mind, move that chair down if it fits for our worksheets. Thank you. Go ahead.
Ryan Rainwater will be juror number 2. Teresa Barnett will be juror number 3. Angela Smith will be juror number 4. Marquise Boston will be juror number 5. Lauren Brown will be juror number 6. Martha Cox will be juror number 7. Donna Holloway will be juror number 8. Patty Hill will be juror number 9. Marcy Lawson will be juror number 10. Chris Dixon will be juror number 11. Jamie Raleigh will be juror number 12. That's 12.
Thank you. Mr. Dixon, I see you have, is that a Bluetooth?
Yeah.
Is it turned off?
Yeah.
Very well.
It's off.
Okay, thank you. Before we begin, I'm going to read a summary of the information. The defendant, Cosmo Kramer, is charged with the offense of murder in the first degree. To sustain this charge, the state must prove the following things beyond a reasonable doubt: that with the purpose of causing the death of Jerry Seinfeld, Cosmo Kramer caused the death of Jerry Seinfeld. You should not, reading the information is merely to let you know what the case is about and the defendant's name. You should not use that information as evidence of any guilt or otherwise consider it other than to understand why you're here today. Okay. For today's trial, we have Miss Rebecca Bush. Ms. Bush, please stand. Ms. Bush is a deputy prosecuting attorney and will be representing the state. And Mr. Standridge, Mr. Brent Standridge is representing the defendants. Thank you. And the defendant in this case today is this gentleman here at the table. His name is Cosmo Kramer. There are 3 other witnesses that you will most likely be hearing the testimony from during the course of the case. Their names are Elaine Dennis, George Costanza, and Art Vandelay. And the attorneys are going to ask you more questions, but if any of you that are seated or any of you who may be seated in a minute know any of those witnesses or know the attorneys, be sure and speak up when you're asked about that. And also, have any of you heard about this case on television or through newspapers?
No.
Very well. And if there's been a little bit of media coverage on this case, if as we go through the process, if you realize that you have heard something, please bring that to the attention of the court or to the attorneys asking the questions, and we'll go into some more about that at that time. Okay. All right, Ms. Bush.
Thank you, Your Honor.
Thank you.
Good morning.
Good morning.
As the court stated, my name is Rebecca Bush, and I'm the Chief Deputy Prosecutor for Saline County. And it is my privilege to represent the people of the state of Arkansas, and particularly those of Saline County. It's my job, after the police have gathered all the evidence in the case, to take that evidence to court and present it to either a jury, as the case may be in this case, or a judge under a different set of facts. So that's what our job is to do. This is the part of the proceedings that we like to call voir, and that's a fancy French term. It means to see and to speak. And this will be our only opportunity, the attorney's only opportunity to speak with you one-on-one and to elicit your responses to some questions to determine whether or not this is the type of case that you can sit as a fair and impartial juror. When you hear that, you think, well, you know, I'm a fair and impartial person. I can be fair and impartial. And I'm sure that you all are. However, there may be something about this particular fact circumstance that might make this case a little bit harder for you to hear fairly and impartially than it would for someone else. What I mean by that is if you had a child that was killed, per se, by a drunk driver, and this was a drunk driving case, then because of your past experiences, your life experiences, then it would probably be too much for society to ask you to sit on a case that is so similar to what your life experience is. So it's those types of things that we are trying to elicit from you to determine whether you can be fair under this particular fact circumstance. There's no right or wrong answers. We just ask that you speak up, tell us what you really think. And that's important to us, is that you don't hold back and that you give us as much information as you have. Now, the judge read the witness list and he introduced the attorneys and the defendant without saying who you might know. Is there anyone who recognized any of those names or knows any of those people? Okay. And I'm not seeing any nods, so I'm going to presume that no one knows the witnesses that are going to be called in this case. I'd like to give you a little bit more about the factual circumstance in case there's something that triggers in your mind that you might remember, oh, I did hear about that. So I'm going to give you some facts, and then after that, I'll ask you if, based on these additional facts, whether or not anything in your mind has been triggered, whether or not you remember anything about this, reading about it in the newspaper, receiving an email, a tweet, or anything such as that. The state alleges, and we anticipate that the proof will be at this trial, that on July the 2nd, 2005, officers from the Benton Police Department responded to a call at the Benton home of Cosmo Kramer, who is the defendant in court today. When they arrived, they found a Dodge Ram pickup, which was a truck belonging to Mr. Kramer, and a Cadillac DeVille belonging to the victim, Jerry Seinfeld, and that was in the driveway of the defendant's home. The truck was parked in front of the car, and the car was smashed into the back bumper of the truck. The driver's door of the car was open, and the victim was found in the driver's seat, slumped over the steering wheel. He was bleeding from a gunshot wound to the neck. When the police arrived, Kramer was standing in the middle of the front yard, and he told police that Seinfeld was a crack pusher and that he had shot him. The victim later died from his injuries. Now, is there anyone, based on that circumstance, which was a little bit more than just an allegation of murder, does anyone recall reading anything about this particular incident in the newspaper, watching it on TV, anything like that? All right. So there's no one that has anything in their past experience, for example, that read anything in the newspaper that you could not put aside and fairly judge the evidence from just the witness stand, the evidence that we present, the witnesses that we put on, the evidence that the judge allows into evidence. And that's what we're looking for, is people who can just decide the case based on the information that's elicited in this court. Ms. Brown, do you think you can do that? All right. And you understand, Ms. Brown, that sometimes when the paper covers a trial such as this, they may have one column to fit in what happens in an entire day. And you sitting as a juror may remember something differently than what the paper puts in there and writes about this case. And the judge will instruct you that you're to decide the case from the evidence in court. Do you think you can do that?
Yes, ma'am.
All right. Does everyone kind of see where we're going with that? And will each of you agree that you will decide the evidence based on what you hear in this courtroom today?
Yes, ma'am.
Thank you. Is there anyone here who's been the victim of a crime? Okay, I saw a couple of hands. Mr. Boston?
My car was broken into.
Okay, and when did that happen?
April 25th of last year.
Okay, so that made a big impression on you because I can remember, you remember the date it happened and everything. Tell me, did you call the police?
Yes, ma'am.
And was that here in Benton?
Little Rock.
In Little Rock, okay. Did the police respond?
Yes, ma'am.
Okay. Were they able to make an arrest in that case?
No, ma'am.
Okay. How did that make you feel? Were you frustrated by that?
I guess I just kind of see it as a part of life. When you're just living in society, then you just may be the victim of something. It's just no way around it.
Right. Yeah, unfortunately, that's quite often the case, isn't it? But I guess what I need to know from you is were you unhappy with the police because of how they treated you, or the fact that you didn't, you felt like they didn't do enough, or do you have any animosity towards the police because of the way they treated you in your situation?
No, ma'am. The city's finest were professional from start to finish.
Okay. All right. And you understand, Mr. Boston, that sometimes there are cases like that. You know, the burglar that went into your car may not have picked a time of day when there were witnesses all around that could have, testified and said, well, we saw, that defendant break into Mr. Boston's car. He probably picked a time when there was no one around in the parking lot. So there often is not a lot that the police have to go on. Do you understand that? Can you accept that?
Yes, ma'am.
Okay. And you felt like you were treated with respect, no problems with the police?
None whatsoever.
All right. And I saw one other hand. Let's see. Was that Ms. Holloway? All right. Could you please tell me what you saw? What happened to
Our
you?
home was broken into 2 years ago, the week before Christmas in 2008, and about $10,000 worth of items were stolen.
Oh, my goodness. Same question. Do you feel like you were treated fairly by the police? Do you think that they took
your... The sheriff's office who investigated, yes.
All
I was
right.
very pleased. Yes.
Same thing. People that break into houses, people that break into cars, they don't typically do that when there's anyone around to testify against them. Did you think that the police did a good job?
Yes. They
All
never
right.
caught the criminals, but they did a good job.
Okay.
But they didn't have anything to work with. So
All right.
no one saw anything.
All right. So that past experience doesn't color the way you're going to view the evidence in this case in any way. All right. Thank you. Now, you're going to hear as the judge reads you some instructions later on in the trial, you're going to hear the word reasonable over and over again. And I think a lot of times when people come into a courtroom, they expect that there's something magical that goes on here. And while we do have a very good system of justice in our country, we want people to come in and bring their common sense and experiences into the courtroom and judge the evidence and reason. Will each of you agree with me and promise me that you will use your common sense and reason in evaluating the evidence that you're going to hear here in court today?
Yes, ma'am.
Thank you. Now, has anyone ever been a juror before? Mr. Boston, how long ago was it that you served as a juror?
This is 2010. I want to say 2002.
All right.
I don't suppose you all could look it up.
Well, that's not necessary. We don't have to have the exact date, but what we want to know from that experience is what kind of case it was.
This was a case where the way it was presented to us that this was a drug deal gone bad, and this drug dealer was accused of stealing someone's car. The drug dealer said that the car was payment for some drugs, so we had to decide if the drug dealer was telling the truth or not.
Okay. So from what I'm hearing you, this was a criminal case. Somebody was charged with a crime.
Yes, ma'am.
All right. And you had to hear the evidence and decide whether or not they were guilty or not guilty.
Yes, ma'am.
Is that right?
Yes, ma'am.
Okay. And did you happen to be the foreman in that case?
No, ma'am.
All right. And then I saw someone else's hand over here. Who did I see that had also been a juror? Okay. I must have just saw something out of the corner of my eye that wasn't right. In hearing the evidence in that case, Mr. Boston, you probably heard the term beyond a reasonable doubt, didn't you?
Yes, ma'am.
All right. And beyond a reasonable doubt, there's that reasonable word again. We're talking about common sense and reason. Beyond a reasonable doubt is the standard of proof. And I anticipate that when the judge reads you the instructions, he's going to tell you that the state, which is me, has to prove that the defendant is guilty beyond a reasonable doubt. Now, we all watch a lot of TV. I know that y'all probably watch CSI and all the other crime shows. That's kind of the it's a really popular theme these days, and all of us watch that. How many of you watch CSI? Okay. And you may have heard other, I'm of a generation that I probably watched more Perry Mason than I watched CSI. But in Perry Mason, I can remember that the prosecutor or the defense attorney used to say, beyond the shadow of a doubt. But that's not our standard, is it, Mr. Boston? It's beyond a reasonable doubt, okay? Because, Mr. Boston, if I was going to have to prove to you beyond the shadow of a doubt that the defendant was guilty, you'd have to witness it.
Yes, ma'am.
To see it with your own two eyes.
Yes, ma'am.
All right. Or I'd have to have a videotape.
Yes, ma'am.
And crimes often don't happen where there's a video camera. Would you agree with me?
Since my car got broken into, yes.
Yes, okay. So that's what we have to prove. Now, in a civil case, if you're called upon to sit during your service as a civil juror, you'll hear the civil attorneys, and they'll do a little thing like this, where they have a way, like a scale of justice, and they'll say if it tips just a little bit this way, then we've proven our case. But that's not the same thing in a criminal case. It is beyond a reasonable doubt. If you have a reasonable doubt in the graver transactions of life, such that you would have in a graver transaction of life, then we have not proved our case. So this is something that's really kind of internal. Ms. Pate, do you understand, or do you think you understand beyond a reasonable doubt that it's something in your heart of hearts, if you are convinced at the end of the evidence that you believe the truth of the matter asserted, that you are convinced beyond a reasonable doubt?
I believe so.
Okay. Does everyone agree with me, or does everyone agree or appreciate beyond a reasonable doubt? Can you accept and apply that law to this case?
Yes.
Who among you has small children? All right. Mr. Dixon, I saw your hand go up first. Tell me how old your children are.
10, and 8.
Oh my goodness. So you have twins or?
No, I got a stepson and a daughter.
Okay.
A son.
All right. So 10 is kind of right in that age where they're still deciding they want to be a teenager, but they're still not quite there. And I've got an 11-year-old, and I can relate to the problems of that age. Do your 10 and 10-year-olds sometimes get in arguments?
No.
They don't?
No.
How about the 10 and the 8-year-old? None of them argue? Wow.
Perfect children. They all get along great.
Well, my goodness, I don't even know what to say to that. Does somebody else have a kid like mine that maybe is not quite as perfect? Maybe that argues with their sibling? Anybody got more than one child? Okay. I knew I had a taker. Miss Raleigh, tell me about how old your kids are.
14 and 12.
Okay. 14 and a 12-year-old. Now, please tell me, do they fight?
Yes.
Okay. Now, how do you decide if one of them says, brother knocked over the lamp, and then the other one says sister knocked over the lamp? How do you decide who's telling the truth?
They both get a chance to explain their story to me away from each other, and I compare the facts.
Right.
And I make my decision on who's telling the truth and the evidence.
Right.
What has happened.
What kind of evidence might you look for?
Maybe.
Okay.
Maybe.
Just, yeah.
If it looks like a foot, probably a foot.
Right. Looks like a duck, acts like a duck, quacks like a duck. It's probably a duck. Okay. And those are the common sense things that we do every day in life, ladies and gentlemen, in determining who is telling us the truth and who might be lying to us. We look at their demeanor. Is that important to you?
Yes.
Do you, if one of the kids has a big project or something that they want to do that weekend and they don't want to get in trouble, might that be a motivation for them to lie? Do you look at all those things, the demeanor, the way they, my little girl can't look me in the face when she's not telling me the truth. And that's a big indicator to me. Do you find that with your children?
Yes.
Okay. And do you find that generally with other people? Sometimes if they won't look you in the eye, you suspect maybe they're not telling you the truth?
Sure.
Okay. And it's all those common sense clues that you have. Judging your children's credibility, or if somebody's trying to sell you a used car, or if somebody is trying to, just convince you of their position on anything, you have to decide who you want to vote for, who you're going to believe, who you're going to buy a car from, and all of those things are it's the same thing you're doing here in the jury box, and you're deciding who you want to believe. Do each of you understand kind of that the juror, you're going to decide what the facts are. The judge will tell you what the law is, but it's your job to decide who do you believe. And you're going to do that just the same way as you would, with your children and refereeing a dispute with them. Now, Miss Raleigh kind of told me a little bit, she's going to look for the shape of the footprint on the wall or so. That's something that she's going to look at. And I believe that the judge is going to instruct you that there are different kinds of evidence in a criminal case. There's what is called direct evidence, and that's if, as we talked about, you viewing Mr. Boston, if you had been there and you had seen somebody breaking into your car, then you would have been able to give direct testimony to a jury saying, I saw the man break into my car and he looked like this, and that's the man sitting right there. That's direct testimony. Circumstantial evidence is what you can reasonably infer from the circumstances. So, Mr. Dixon, if you wake up on Christmas Eve morning and you go and you open the door and it's snowing and it's going to be a beautiful white Christmas, and there are footprints going from the door to your car in the driveway. What can you infer from that?
Well, depends on a lot of different things. If I'm the first one up, then that would be, kind of curious why there would be footprints from there to my car. But I mean, if I'm the last one up and my wife's up and the kids are up, someone obviously walked my car.
Okay.
So
Somebody,
what's going on?
yeah, you may not be able to tell who, but you can tell if there are footprints from your door to the car that someone walked that way, couldn't you? Okay. Does everyone understand that sort of an easy example or an oversimplified example? But the fact that there are footprints in the snow typically will indicate that someone's walked through the snow and left the imprint. An easy example of what circumstantial evidence is. And sometimes that can be quite powerful. Would each of you agree with me on that? Ms. Smith, as you can see, Mr. Kramer is an elderly gentleman. He's about in his 70s. How do you feel about sitting in judgment of someone who may be in their late 70s?
I believe I can do it. Would be fair.
All right. So if I'm hearing you correctly, then you're saying that you would not necessarily feel more sympathetic towards him because of his age. Is that right?
That's correct.
Okay. Is there anyone, Ms. Pate, let me ask you this. Do you think that a person, even in their late 70s, should be held responsible for the actions that they take?
Yes, I do.
All right. Does everyone agree with that? Ms. Lawson, by the nature of this case, you've heard from the judge, and then I've read a set of facts. You may be called upon to hear some testimony that may be medical, maybe from the medical examiner's office. There may be pictures describing wounds or treatment that is given to a patient. And you might be called upon to look at some pictures that would just be, in common parlance, would be kind of gruesome. Do you think that you would be able to rise to the occasion to look at it, to satisfy yourself whether or not we've proved our burden? Or do you think you would be so inflamed by gruesome type photographs or graphic testimony that you think you just couldn't make a decision in this case?
No, that would not bother me.
Okay. All right. Does everyone else, I'm sure that none of us would want to do that, but does everyone, and Ms. Boston, I'll come back to you. Does everyone else think that they could look at those photographs and still make a decision? If you had a question about the injury, you could look at those photographs and still come to a decision based on that? Or do you think that you would be so put off by the pictures that you just couldn't deliberate? No? Mr. Boston, you had something you wanted to say.
Yes, ma'am. I wanted to ask you, if the pictures are just extremely graphic, is there any way we could get a heads up? Just like, could someone describe it so that we know to expect this, as opposed to just putting it on the screen and it's just kind of in your face?
Mm-hmm. Well, I anticipate that you will probably know that those photographs are coming through the medical examiner, for example, who will testify about the cause of death and things of that nature. The crime scene photos that will be presented by the police officers. So through the course of the direct examination and the opening statements, I think you'll pretty much have a good heads up that those are coming. And if that were so, and I pretty much know how they're going to be used in this case, do you think that you could still make a fair and impartial judgment?
I could, but if I just didn't want to see them, then could I ask to be stricken from the jury so I just don't have to watch them?
Well, no, and that's the kind of thing. I mean, once you're a jury, it's kind of like being pregnant. Unless something else happens that disqualifies you, then you're on there. You're either a juror or you're not. And if someone, of course, gets sick or something like that, then with the judge's indulgence, we might get an alternate, and they could be replaced for that. But for something like not wanting to be the evidence, that's something we really need to know now. And if that's how you feel, then I really appreciate your honesty in letting me know that, because that's important.
I would not want to see graphic pictures.
All right. I appreciate that. Thank you for your honesty.
Can we want to address that now? Are you?
Your Honor, I believe that Mr. Boston has been quite honest with us, and he has told us that he just simply feels like he would not be up to the task of looking at a photograph that would be gruesome. And for that reason, I believe that the state would move to excuse him for cause at this time.
Mr. Standers, do you have any response?
I don't have any objection to that, Your Honor.
Okay. Mr. Boston, thank you very much for your attendance today. You may still be called for another type of case, a civil case or another criminal case. I'm going to go ahead and notify the clerk if there's any kind of violent cases you may need to be called or take up any extra time. But again, I do appreciate your service, and you are free to go.
Yes, sir. Thank you.
Thank you.
Just
Come on down.
Now, did you guys see how he wound up being stricken from being a juror? And the reason why he was stricken from being a juror, because he couldn't deal with looking at gruesome pictures. Being that he couldn't look at evidence that would have such visual depictions, they struck him. They said, "Thank you for your service. Have a good day." Just so that's one juror gone, and that's a reason. There's one reason. That's one reason why a juror might be removed. Okay. Let me continue. Nuni, by the way, mommy. Do you guys hear me?
Yes.
Check your Cash App.
Okay.
Okay, I'm going back on mute and I'm continuing.
Madam Clerk, would you call another juror?
Michelle Hill will be juror number 5.
Thank you, Ms. Hill.
Ms. Hill, you've heard a lot of questioning up to this point, so I'm going to go ahead and see if we can kind of bring you up to speed. Did you understand the burden of proof beyond a reasonable doubt?
Yes, ma'am.
Did you have any problems with looking at the graphic photographs?
No.
All right. Have you ever been the victim of a crime?
No, not really.
All right. And have you ever served as a juror before? Okay. Was there anything else that you heard of as we were questioning along the process again, but is there anything that made you kind of think, well, I probably need to mention this if I get called? Do you know of any reason that you can't be fair and impartial under these facts? Thank you. All right. I anticipate that the judge will probably instruct you on something that's called self-defense. And Mr. Rainwater, may I please ask you this question? Does it make sense to you that the law only permits a person to use deadly force to avoid injury or risk to one's own safety? Does that make sense to you?
Yes, ma'am.
Do you think that's a good
I'm
law?
going to object to that. I don't think that's a correct statement of the law.
Your Honor, I
That's
believe.
correct, Ms. Bush. There's other reasons it can be used.
Absolutely, Your Honor. But for the fact circumstances that we have, I think that that is an accurate statement of the law as applied to these facts.
Not sure it is, Ms. Bush.
I'll move on then,
Okay.
Your Honor.
Sustained.
The court is going to instruct you that one who provokes the conflict or who was the initial aggressor cannot claim self-defense unless he withdraws from the conflict. Mr. Rainwater, do you think you understand that?
Sorry, can you read it again?
Sure. The court will instruct you that one who provoked the conflict or who was the initial aggressor cannot claim self-defense unless he withdraws from the conflict.
Yes, ma'am.
Okay. Does that make sense to you?
Yes, ma'am.
Okay. And in fact, we probably all know that from the schoolyard. Would you agree with me that, you know, when we were youngsters playing on the schoolyard, if there was a bully and he picked at the little kid, and the kid just gets enough of it and wallops him one time, well, he kind of pretty much deserved it, didn't he? The bully?
Did the bully deserve it? Possibly.
Okay. And my point is, that's just something that we know from just being kids on the playground. You can't pick on somebody and not expect that they might strike out in response. Okay, would you agree with that?
Yes, ma'am.
All right. Can you accept and apply that law?
Yes, ma'am.
All right. Can each of you accept and apply that law?
Yes.
One who brings on the conflict may not be able to complain later on if they are hurt. Right now, I'd like for the judge to please put up on the monitors, if we could, the statute. We talked about beyond a reasonable doubt, and now I believe that the judge at the conclusion of the trial will instruct you as to the definition
Mr.
of
Harris, could you turn it on?
first-degree murder.
It's on the side. Use the bottom button. The bottom top. Maybe top. Again.
There it is. All right. Cosmo Kramer is charged with the offense of murder in the first degree. To sustain this charge, the state must prove the following things beyond a reasonable doubt. That with the purpose of causing the death of Jerry Seinfeld, Cosmo Kramer caused the death of Jerry Seinfeld. All right, so this is what the legislature has defined first-degree murder as applied to this factual circumstance to be. So the law lets us know exactly what you're going to be called upon to deliberate. It tells you what things must be proven beyond a reasonable doubt. Ms. Brown, do you understand that if we prove that with the purpose of causing the death of Jerry Seinfeld, Cosmo Kramer caused the death of Jerry Seinfeld, we've met our burden of proof? Yes. Do you understand that? Okay, do each of you understand that?
Yes.
So we don't have to prove, for example, if the defendant was wearing blue socks or mauve socks. There could be a reasonable doubt about that. We don't have to prove if it was a cloudy day or a sunny day. There can be a reasonable doubt about that. But we must prove that with the purpose of causing the death of Jerry Seinfeld, Cosmo Kramer caused the death of Jerry Seinfeld. All right, will each of you hold me to that burden and only that burden?
Yes.
Thank you very much. Now, there are some definitions that go along with this statute and purpose. Purpose is a state of mind. A person acts with purpose with respect to his conduct or as a result thereof when it is his conscious object to engage in conduct of that nature or to cause such a result. So basically what that means is that he killed him and he meant to do it. Do each of you understand that? Ms. Hill, how do you decide when you are trying to determine what is somebody's intent? What are some of the things that you look at?
Like pre-planning, if they've thought about it before.
How do you tell if they've thought about it before? Because we can't really open up their head and look in. So how do you find that?
If it's something that's well planned. Like if he knew, like if you know someone's going to be home, thing.
Okay.
You've thought about it beforehand.
Right.
So you planned on doing that act.
Right. So planning is important.
Yes, ma'am.
Sometimes by taking an action, does that somebody's mind?
Yes, ma'am.
Okay. So if I take a big old heavy frying pan and I wallop somebody upside the head, then I know based on my common sense and reason that I'm probably going to hurt them pretty bad with that thing. Wouldn't you agree?
Yes, ma'am.
So while I didn't say anything about it, my actions indicate that I had the intent to hurt that person.
Yes, ma'am.
Do you understand that it's those types of things that you will have to be called upon to determine what's in someone's mind? I always like to end with just a general question. Is there anyone that has anything? For example, we had Mr. Boston, who was very honest about his reticence to look at those pictures, and I appreciate that. This is probably not the case for him to sit on. Is there anyone else that during the questioning has thought something else? Oh, I probably need to mention this, or there's something else that you feel is important for either myself or Mr. Standridge to know about in deciding whether or not you would be a good juror for this case? No? Well, then I appreciate your time and attention, and I'll turn it over to the court at this time.
Okay. Do we need to take a break or you want to keep going?
Rather keep going, Your Honor.
Very well, score. You may proceed.
May it please the court, counsel, ladies and gentlemen. My name is Brent Standridge, and I represent Mr. Kramer with respect to this matter. And as Ms. Bush said, this is the phase of the trial that we call Voir. You hear that pronounced different ways. I think she said voir dire, which is a French pronunciation, which is what it really is. But at least in this part of the country, a lot of times we refer to it as voir. But whatever the fancy term is, it is a mechanism by which we use to select jurors. And in a normal case, I would probably not know any of you, and the only information that I would have to pick a jury would be based on juror questionnaires and the responses to any questions that I get from you in this court. And that's kind of the selected method that we have to select jurors. So it's for that reason, my purpose is not to pry or embarrass anyone. And if it seems as though I'm doing that, I hope that you just hold that against me and not my client. But it's to obtain information. So the more information that you can provide to us, the better that we're able to make an intelligent decision as to whether you should serve as a juror in this case. We will exercise challenges. We have challenges for cause. You already saw that this morning. We also have peremptory challenges. Those are mechanisms by which the attorneys pick who a juror is and who a juror is not going to be for this case. If you are challenged, that is not a personal attack on you, and please don't interpret it as such. It's just the feeling the attorney believes that you may not be right for this particular case. And we're human beings too. We can obviously be wrong, but please don't take that as a personal attack. One thing that I should mention, since this is an information gathering process, sometimes a prospective juror will believe that it is important for the attorneys in court to know something, but they would rather not talk about it in the presence of everyone else. And that's fine. If you are one of those people, or you do have one of those concerns, I believe that if you would ask the court to do so, we could take the matter up in chambers outside of the hearing of the other jurors, because we do want as full and complete disclosure about these matters as we possibly can have. And if you have a concern, if it's important enough for you to think, you know, that's something I really want them to know, then it's important for us to know it. So if anybody falls into that category and you want to give a response to a question or want us to know something, we certainly can take it up in chambers if you want us to do that. Now, I had mentioned jury questionnaires a little bit earlier. And again, before we select a jury, we review the jury questionnaires, which has some very general information on them about who the person is and, where they work and some other general type of questions. And it's been a while since those jury questionnaires have been completed. Are there any of you here today who say that, there's something on the jury questionnaire that you believe is different than it was when you initially filled it out, or that you might think is not a correct response to any of the questions that were asked on the jury questionnaire? Does anybody fit into that category at all? All right, thank you. You have been asked about whether you have heard anything about the case, and you've heard the information read to you. Mrs. Bush gave you kind of a factual overview, a very brief overview of the case. I anticipate that the facts, as is true in a lot of these cases, are going to be contested. It's important to hear all the evidence before making a decision in this case. And we anticipate that the evidence is going to show, Mrs. Bush mentioned self-defense in the case, that my client was almost going to be run over by a car driven by the decedent, and that's why he had to respond the way that he did. That's where the self-defense comes into play. But does everyone understand it is important to hear all sides of a story, everything about a case before you make a decision? If the judge so instructs you, do you believe that you would be able to follow that decision and apply it to this case? Thank you. Now, the list of witnesses have been read. The decedent in this case is Jerry Seinfeld. Do any of you know any of the witnesses or any of their family members at all? Thank you. There's been some discussion about, I guess you would say, pretrial publicity. And I assume from what I've heard that nobody has really read anything about this case or heard about it in the newspaper or talked about it in the coffee shop or anything of that nature. And my background's in journalism. I think it's important to have reporting of cases and all of that kind of thing. But it's quite different when you're a juror and you sit in a courtroom, because you're there for the whole story. And will you all agree that that is the only way that you can arrive at a proper and correct conclusion, is to hear the whole story? And does everyone understand, sometimes when things get reported, it may be somebody that listens 5, 10, 15 minutes of a trial, something like that. You're not going to get the full story. Are you all familiar with that concept? Thank you. Now, the attorneys in the case, Ms. Bush has introduced herself. She works for the prosecuting attorney, Ken Cassidy. And then there are a number of deputy prosecutors in that office. There's Kerry Robertson, Chris Walton, Vince Shoptaw, Shay Mealer, Brian Clary, Mike Sappington, Jeremy Hutchison. And then there's also a lot of the support staff people that work there. Do any of you know any of these individuals on a personal or professional level? Yes, ma'am. Ms. Martha Cox.
I know Shay Mealer.
You know Shay? How do you know Shay?
We attend church together.
Would the fact that you attend church with Ms. Mealer, would that cause you to believe that you could not be a fair and impartial juror with respect to this case?
No.
If you were to decide after hearing all of the evidence in this case that my client was not guilty of anything, would you feel compelled that you would have to explain that decision to Ms. Mealer in any way?
No.
Very good. Anyone else? My name is Brent Stanridge. I have a law office here in Benton and have a general practice of law. And Ms. Pate used to work for me at one point in time. Now, Ms. Pate, when I single people out, I want you to understand I'm not trying to embarrass anybody or you put them on the spot or anything like that. It's just part of the process. It's important for that information to come out. Ms. Pate, by the fact that you used to work for me before, would that cause you to believe that you could not be fair and impartial with respect to this case?
I don't believe so. I haven't worked for you in a while.
Okay, very good. And Ms. Barnett, I currently work with you now. Is there anything about that? You're not my employee. We obviously just do work together. Anything about that that would cause you to believe that you could not serve as a fair and impartial juror in this case?
I don't think so.
And Ms. Smith, I'll ask you the same question. Anything, we obviously work together now. Is there anything about that that would cause you to believe that you could not serve as a fair and impartial juror in this case?
No.
I believe Ms. Bush had asked whether any of you had been victims of crime, and we had some responses on that. Have any of you had family members that have been victims of crime? Yes, Mrs. Holloway.
My niece was killed by a truck driver when she was 16.
Okay. Now, this case will have facts that are quite different than that, but by virtue of the fact that that did happen, that you had a family member that was a victim of a violent crime like that, would that cause you to believe that you could not serve as a fair and impartial juror in this case?
No.
Anyone else? One of the witnesses that was mentioned was Officer Art Vandelay. And it's typical in many criminal cases, not surprisingly, you'll hear police officers testify. They may have central roles in a case, or they may have minor roles in the case, but they're still police officers. Is there anyone who believes that just by virtue of the fact that someone is a police officer, that you should give their testimony greater weight or greater credence than someone who is not a police officer? Do any of you have any of you served, or do you have any family members that have served in law enforcement? Ms. Payton.
I have an uncle that's a sheriff for Garland County.
Would the fact that your uncle is a sheriff for Garland County, would that cause you to believe that you would kind of favor the state, or you would tend to believe a law enforcement officer's testimony more than you would the testimony of any other witnesses in the case?
Not necessarily.
Obviously, you'd want to hear what all of the facts and circumstances are before you made up your mind. Is that correct?
Sure.
The court will give you instructions. We have talked about some of those today, but and we really won't know what all the instructions are until all of the evidence is in and the judge gives you those instructions at the end of the case. And some people may hear an instruction and say, you know, I just don't know if I really agree with that or not. But what I want to find out is this: the judge's instructions are the law, and you're to apply the law to the facts and evidence of the case. Do all of you believe that you can apply whatever the instructions you get or the law? Can you apply those to this case? Or would you say, I don't care what it says, I'm not going to pay any attention to it? Do we all agree that it is important when the judge gives instructions that are the law, that those instructions be followed? Among the instructions that you will receive, Ms. Bush has talked about instruction on common sense, which I agree is a very important instruction. Common sense has a place in almost everything that we do in society, and it certainly does when you're talking about a court case. I also anticipate you will receive an instruction that concerns a presumption of innocence, that when someone is charged with a crime, they're still presumed to be innocent, and that presumption stays with them throughout the course of the trial unless and until their guilt is established beyond a reasonable doubt. Do all of you agree with that instruction? If the judge gave you that instruction, do you believe that you could apply and follow that instruction in this case? Another important instruction, and I want to say, just because we're talking about a few of them, we're not trying to say the others are not important, because all instructions really are equally important. But we want to point out a few that we think are particularly applicable to this case. Credibility of witnesses. It will be your job to decide what the truth is in this case. And to do that, you have to decide, well, who's telling the truth and who's not telling the truth. And you and only you get to decide it. You know, it's a function of the court to give you instructions of law. It's your job to decide what to believe and what not to believe. Do y'all believe that you're capable of doing that? You know, that's a heavy responsibility. You know, it's a tough responsibility, and it's a heavy burden to put on someone. But is there anyone who believes, you know, this credibility of witnesses thing, if it's going to be tough and I really can't decide, I'm just not going to be able to decide one way or the other. Does anybody really feel that way, or do you believe that you're capable of really getting into a case, determining where the truth lies? Can you all do that? Mrs. Bush had mentioned the burden of proof in this case. The state has the burden of proof, and that standard is beyond a reasonable doubt. And as she said, it's not beyond a shadow of a doubt or beyond any and all doubt, but it is beyond a reasonable doubt. And I anticipate that the instruction that you will receive will provide that if you're required to pause and hesitate in the graver transactions of life, that is when you have a reasonable doubt. So graver transactions of life, if I'm buying a house, if I'm buying a car, if I have to decide whether to have surgery in the hospital, those are all grave decisions that we may have engaged in. And you may ultimately decide to buy the house, buy the car, have the surgery. But if you pause and hesitate during that process, that's when you have a reasonable doubt. Does everyone understand that process? Do you all believe that you can follow that instruction if that's the instruction that you receive on the burden of proof or on the standard of proof? It will also contain a definition that says if you're convinced of the defendant's guilt, you have to have an abiding conviction of the truth of the charge. That's the standard. Do you all believe that you can apply that standard as well? Ms. Bush talked about, and it was put up there, murder in the first degree. That's what my client is charged with. It has components or elements is what we call them. You have a mental state. Purpose was the mental state that was given. It has to be somebody's conscious object to kill. Every how many elements that there are, because there may be other instructions that contain elements as well. Does everyone understand that it is the state that has the burden of proving each element of a crime beyond a reasonable doubt? So if they just prove 4 out of 5, Ms. Smith, what would your verdict have to be? That's correct. I'd also mention murder in the first degree. There very well may be other offenses as well that you receive instructions on. It just depends on how the proof develops. This type of charge is a homicide charge. So you could conceivably receive instructions on murder in the second degree, manslaughter, negligent homicide possible. Does everyone understand that there may be a number of alternatives when it comes to a homicide that you may need to consider? Do you all understand that? That would not be surprising if that were the case, because lots of times in homicide cases, there are different alternatives that you'll have. We will actually have 2 different phases. We will have a guilt innocence phase, and then if you were to find my client guilty of some crime, then we would have a punishment phase. This will be the only opportunity, though, that we get to talk to you and ask you questions. So I'm going to ask you some questions about punishment. But keep this in mind. I also anticipate the judge will give you an instruction that tells you that you're not to consider punishment when you go out and decide guilt innocence. That has to wait until the second phase of the trial if there is one. Having said that, murder in the first degree, I anticipate you will receive an instruction that offense is punishable by 10 to 40 years or life imprisonment. Do each of you believe that you could consider that full range of punishment?
Yes.
Is there anyone who believes, that's just not an appropriate punishment for that type of offense, and I could not consider that full range? Does anybody feel that way? You may receive an instruction on murder in the second degree. In murder in the second degree, I anticipate the court would instruct you as a Class A felony, punishable by 6 to 30 years imprisonment and or up to a fine of $15,000. Same question. Is there anyone who believes with respect to that offense that they could not consider the full range of punishment if you receive such an instruction? Very good. The next offense that you might receive an instruction on is manslaughter. And I anticipate that if you receive instruction on manslaughter, the court will tell you that the range of punishment is 3 to 10 years imprisonment and or a fine of up to $10,000. Is there
Do you hear me, guys?
Yes.
I have a question. So I wonder, did they ask the same kind of things about R. Kelly? Because remember, this is the defense side now, questioning the jurors. So do you think so? He must have been in there that the lawyers were in there asking those same kind of questions, like, do you know the charges for this crime is this? Do you think that, you know, being that these are crimes against minors, do you think that 90 years is sufficient time for his crime? And they were probably like, yeah, that's enough time. Definitely. What do you think, Noonie? I can imagine what that voir dire was like.
Well, it seems like it would be mostly like what we read too, right? Like, all those questions they want to know, if they've heard things about him, because obviously he's way bigger than any just regular person. Everybody pretty much knows him.
Right. But, they were asking too, I'm pretty sure they were asking too about the sentencing and what you think about the crime, the charges.
Oh yeah, or if anything's
And if
ever
you'll
happened to
be
them
able
like that.
to, right, like, because remember, it's more than just, now remember that questionnaire is what gets you into this room. Once you're in this room, they start picking out your names and then they put you in the jury box. And then they start picking you out little by little until they get the exact amount that they need or the exact people they feel that are enough. And then the rest get dismissed.
Weeding them out.
Yeah. The defense should have, what did she say? The defense should have, I don't know. I don't know either. I'm sure they did, right? I'm pretty sure they did too. It's part of the process. Remember, they have to try to withdraw as much honesty as they can from these people. They have to speak the truth. This is a voir dire process. Now is the time for you to speak the truth or forever hold your peace. And some actually forever hold their peace. Look at the ones that came out for for Miss Maxwell. Now she might get a new trial just because the guy was holding it in, didn't let nobody know. All of a sudden, he let it out.
What
You
a
know what I'm
dumbass.
saying? He held the truth until he forever decided to hold his peace. And he said, I'm not going to hold it right now. I'm going to let you know. Well, I was on the juror, but I was sexually abused as a child. But that didn't make my decision. But no, you were supposed to let them know at this process right now. You were supposed to speak up, to speak the truth and say, no, I feel this way, and yes, I feel that way. Now is the process that you're supposed to do that. You can't go in being dishonest in your heart. Yes, honey.
And they're gonna go after him now.
Right. Hold on.
These were some long videos. Whew.
All right. Sorry about that. Pause for a second. So, yeah. So let's continue this process, and then I'm going to go into the next thing, okay?
Okay.
Is there anyone who believes that they cannot consider the full range of punishment with respect to that offense? Finally, we have negligent homicide. Negligent homicide is a Class A misdemeanor, and it is punished by up to 1 year in the county jail and or up to a $2,500 fine now. Is there anyone who believes that that is not an appropriate range of punishment for a charge such as negligent homicide? Does anyone believe that they could not consider a negligent homicide because there was a death involved? And you might say, well, a Class A misdemeanor, I could, if there's a death involved, that's never going to fit under any circumstances. Does anyone feel that way at all? All right, thank you. The judge read you the charge, and we charge in state court by information or indictment, usually by information as it was in this case. The prosecutor actually files that information. That's how the case gets started. I anticipate the court will give you an instruction that the information or the charge is not proof of anything. That is just a mechanism by which we get someone to trial. Does everyone understand that concept? Does anybody believe that, well, just because the prosecutor filed the information, my client must be guilty of something? Does anybody have that belief as we sit here today? This case, I guess, is a fairly typical case. It is anticipated that it will take about 1 day to try this case, but it might go into a second day. We appreciate the fact that you're here. This is obviously taking you away from your work and family and friends. It's a sacrifice, I know, to be a juror. Is there anyone believes, though, that should this trial go into, say, 2 days, that you would have some sort of business going on or something that you just could not do that? Does anyone fall into that category at all? Yes, Ms. Hill.
I have children pick up at 2:45.
You have children pick up at 2:45, okay. Then I think those kind of things the court can generally accommodate. But sometimes we have people who say, they have a business, or maybe they have to take care of somebody who's very ill, and so their mind really can't be focused, on a case for that period of time. Is there anyone that falls into that category at all?
Excuse me, Mr. Stanton. Ms. Hill, do you have child care for the children?
No.
Okay, so you have to be picking the kids up at 2:45. Okay. Do you have any other options? Is there someone you could call?
No, I don't think so. I don't think they kept the vehicle home today, and knowing that I was supposed to pick them up.
Okay. Do either of you have any objection for me excusing Ms. Hill?
No, you're not.
No, I have no objection.
Okay. All right, Michelle Hill, another Patty Hill still on the jury. You're still on the jury, but Ms. Michelle Hill, you are excused today. And go ahead and call the clerk's phone. I think our next trial is scheduled for next Thursday, so just go ahead and call before then. Thank you. Is there anyone else that, while we're on that subject, we got to finish the trial today? Maybe going tomorrow, probably won't. Is there anyone else that has an issue about child care or an elderly parent or anything like that they need to take care of? I expect Voir will take another 10 minutes or so at the most, and we'll have a break after that. But anybody else that we probably should have ferreted out in this hill a while ago. But anybody else, any issues like that whatsoever? Okay, all right, let's go ahead and Ms. Clerk, if you could call another juror.
Tiffany Gray.
You see how another one got dismissed? This one got dismissed because she didn't have a babysitter.
The judge stopped that real quick. He's like, we don't have no other accommodations for her.
I was like, Okay, honey. All right now. She got off real quick. She's like, listen, I don't have a babysitter. I gotta get out of here.
Mhm.
So this is another way you can get dismissed. And this is basically the process, the elimination process that it goes, and this is how it is. So I just wanted to show you guys this video of the process. And I know that that was like long, and I know that court process stuff sometimes is boring, but I think that this was very informative, especially for what we are into right now. And, you know, we're trying to learn the court process and what is voir dire and how it works. So I finally found the information that Bone Jean had put in for her motion, which was for the new trial. So I'm going to stop sharing the video. We did that. That is done, guys. That is over with. And in the process, I'm cooking in the background. So that's another reason why this was kind of a good idea, because I can cook, stop, let the video play for a little bit, do my thing, come back. You know, dinner will be done soon. Couple more minutes. Whatever, catch the replay, y'all. Catch the replay. So now in Bunjean's motion, which it wasn't a motion, it was a memo. She put in a memorandum of law in support of R. Kelly's motion for a new trial. Now she put this in, and in it here, she talks about how the defendant was denied effective assistance of counsel where his trial attorneys failed to conduct a meaningful voir dire of potential jurors and challenge unqualified jurors, some of who had watched the inflammatory docuseries Surviving R. Kelly or were familiar with prior accusations of sexual abuse of minors against defendant, and counsel's unreasonable performance during voir dire resulted in the impaneling of a jury that was neither fair nor impartial. So that was one part, and the other part was about the conflict, and we'll talk about that another day. So, okay, let me go down to where we need to go to. Nuni, is that you?
What?
I don't know if you got all this stuff going on in the background.
What's that?
I don't know. It sounds like squeaking or something.
I don't know.
So what's something back there? I'm like, okay, what's going on over here? Okay, here we go. Let's see. Cheers. What's up, my love? Okay, wait, better thing. All right, this is just the introduction. Okay. Here we're gonna go into, they talk about the argument, right? And in the argument, as we said, it was about the defendant's effective counsel where his trial attorneys failed to conduct a meaningful voir dire. She says, as United States Supreme Court Justice Black stated in re Michael, and she stated a whole case, it is difficult to conceive of a more effective obstruction to the judicial process than a juror who has prejudiced the case. She said this is because due process means a jury capable and willing to decide the case solely on the evidence before it, and a trial court ever watchful to prevent prejudicial occurrences and to determine the effect of such occurrences when they happen. Right? So the right to a jury trial guarantees the criminal accused a fair trial by a panel of impartial and indifferent jurors. Now it says that Rule 24 of the Federal Rules of Criminal Procedure governs that voir dire in criminal trials. The rule provides that if the court examines jurors, it must permit the attorney for the parties to A, ask further questions that the court considers proper, B, submit further questions that the court may ask if it considers them proper, and a trial judge who under Rule 24 decides to examine prospective jurors himself must at the very least solicit questions from both parties' attorneys. So naturally, the trial court's duty to ensure that each and every juror is fair and impartial is heightened, whereas here, pretrial publicity has greatly increased the odds that a potential juror has preconceived views of accused guilt. Okay, so now let's go to where she talks about it. Okay. She said that perhaps the most troubling and most of the defendant's jurors were aware of prior allegations of sexual abuse against him, and several seated jurors had actually seen a scathing one-sided docuseries entitled Surviving R. Kelly that portrayed defendant as a serial predator and included interviews with many of the government's witnesses. I'll bet outside the adversarial process, defendant's jurors should not have included a single person who saw the documentary Surviving R. Kelly. So, then she starts to put examples, right? For example, she says juror number 3. Question 29. See, it was question 29. Right? I think we marked that one, Noonie, right? I believe it was
Yes.
question 29. Now, juror number 3. So that's one juror. Let's count how many jurors she was. Who was it that asked the question? Truth Strong, right? She said, how many jurors was she talking about, right? So let's see. Juror number 3 is 1. Wait. This one was question. Juror number 3 is 1. The other one is juror number 4. That's 2. Juror number 5, that's 3. Juror number 7, that's 4. Juror number 8, that's 5. Juror number 9, that's 6. Juror number 11, that's 7. Juror number 12, that's 8.
So all of them down there.
That's 8. That's 8. 8 jurors.
Out of what, 12 and 2 alternatives?
Out of 12 and 3 alternatives. That's crazy. What? That's why I said, you know, but like I said, you see how the voir dire process is though? Remember in the first video how he was breaking it down? How you have to have people for the defense and against the defense. The same thing with the prosecution. They have to be able to have a balance. They have to have a balance. But it's the other stuff that goes into play with them. You know? Let's see, let's go to, like I said. So the question was for juror number 3, which was, let's say, number 1, the first one she complained about. The case for which you are summoned involved the defendant Robert Sylvester Kelly, aka R. Kelly. Have you read, seen, or heard anything about the case, alleged crimes, or people involved? And then the answer was, I watched the documentary, but I forgot the name of it. So that's a conflict according to her. So the person shouldn't have watched the documentary, is what she's saying, right? Then the other question, question 30, was, have you read, seen, or heard about Robert Kelly, also known as R. Kelly? And she said, oh, he said, yes, the entertainer. And then their lines was, which she, you know, boldly put, I heard that he has been sleeping with underage girls. That's the cause right there. So the first reason to strike for cause is because this person said, I watched the documentary, but I forgot the name of it. As well as I heard he been. So that's a reason to strike. Right? The other question is, what were your general impressions? And then juror said, I saw a documentary about him and his legal troubles. She highlighted that. That's specifically what she's trying to point out. That these people did wrong and that there is show cause that they should have been ejected. Matter of fact, let me see if I can share my screen. Hold on, guys. I just realized that I wasn't sharing my screen. Hold on. Okay. Oh, wait. Oh, I'm going to have to go down, one down. All right. All right. Can you guys see it?
Yes.
Okay. All right. Hold on. Alrighty. So you see where I highlighted it, those are the questions, those are the answers that are in question. I watched the documentary, but I forgot the name of it. I heard that he has been sleeping with underage girls. I saw a documentary about him and his legal troubles. And this was all from just juror number 3. Then the other one here, but she didn't highlight anything. But the other question was, do you know anything about the Me Too movement? And this person said, yes, it's a movement that seeks justice for rape victims 25 to 30 years after the fact. Okay. Then juror number 4 was asked this. The charge case involves allegations regarding exposure to one or more sexually transmitted diseases. Is there anything about such allegations that you believe would affect your ability to serve as a fair and impartial juror? He said yes. Why would they keep this person in? I am confused.
Yeah, I agree with that one. That was the one where he blatantly said yes.
Right, like
The other ones,
the other one, really? Right.
because even like how we were just reading when it said like even if like they just want you to tell like if you've seen it or heard anything, whether you believe it or not.
Right. And can you be fair and partial? Now, this dude right here is like, yes, and I find transmission of STDs in a non-consensual act to be particularly repulsive. Why did they keep this dude in here? He definitely should have been ejected. That shit should not, this person should not have been in there at all, just because of that alone. Then the next one says, have you ever known anyone, including yourself, who was the victim of a sexual assault, other assault or homicide or other acts of violence that required medical treatment or counseling? And then he says, yes. He said, yes, close friend, because remember they said if you do know, if you do say yes, explain who without saying who, right? That he said, yes, a close friend received asylum due to sexual assault and infection with HIV from the police in a foreign country.
Wow.
I mean, like, even though it was from a foreign country, he still should not have been put in there. But he should have been for real. Then the next one was, which publicly known person do you least admire? Remember, we read that, right? Question number 78. Y este que dice, Jeffrey Epstein. And they left this guy in here. No. As we witnessed today, the Voir process. No. He definitely should not have. The other young lady, I think the prosecutors are going to fight that one. This guy right here, they were wrong. Everybody in there was wrong. I'm sorry. And it could just take this one guy right here to get a whole new trial just because of one guy right here. As we watched and learned today, just because of this one guy right here, there could be a whole new trial, yo.
But that's crazy how like his attorneys even just like let that go. So that's why I feel like they did that on purpose.
How they did that on purpose, exactly. You see, now we're thinking this was all strategized. This was strategically done because, in all honesty, I'm pretty sure everyone in there knows that R. Kelly really did not get a fair trial due to his ineffective counsel and what was going on. And then to top it off, his counsel decides to drop out 2 months before the trial starts. There's a whole conflict of interest. Now they withdraw. You have these other two attorneys, but one has a conflict. The other one doesn't. Now he hires 2 more lawyers. They come in. They only have 60 days to catch up. So, in all honesty, I think Judge Ann and everybody else got together somehow, some way, and said, you know what, it is what it is. And then you could come in on appeal and we could fix it later on. But we got to continue this trial. We got to do this trial the way it is. Because remember, there's always meetings in the chambers, the judges' chambers.
Yeah.
They always have meetings. They talk about things. They discuss things. They discuss strategies. Does anybody watch Law and Order? If you see, that's what they do. They talk about the strategy of the case and how it's going to go. The judge tells you right then and there, no, you can't do that, or yes, you can do that. Well, if you get me this summons and subpoena, then maybe it'll work and we can bring it in. Or if you bring that witness, then fine, bring it in. No, you can't do that. That's against the law unless you find a loophole. You know what I'm saying? This is what they do in the judges' chambers. So I'm pretty sure this was all strategically done. Because come on, in reality, yo, really?
And it's hard to even think that Judge Ann, she didn't even say anything about that. Like, do you know what you're doing? Like, because the judge also would have to bring that up. Like, you know, like, are you sure you're going to let these jurors in?
Yes, right. That's just like and I'm pretty sure we didn't see the voir dire process. We didn't see that happening at all at his case. So it's hard to tell what went on. You know? All right, being that it's on the screen here. All right, so Mommy, you want to read a little bit? Do you see what's on the screen?
Okay. So juror number 5 disclosed the following in his or her questionnaire. Question 31, have you watched or heard any interviews of Robert Kelly or any TV shows featuring him or any specials or documentaries about him? The juror said yes. The question was, what were your general impressions? That he loves underage girls. The question, from what you have seen or heard, do you have a general impression of the defendant? And the juror said somewhat negative. The question,
somewhat negative. Like what? Why would you even, just because you said that alone, somewhat negative? Then the next question was, go ahead.
Why do you feel that way? And the answer was the allegation that related he was sleeping with underage girls, minors. Although the court asked the prospective juror general questions about her ability to put aside other things she might have heard, when asked if he or she could be fair, the juror indicated that he or she would give it a shot.
I'm gonna give it a shot. This person right here, another one that should have definitely have gone. Because you should have said, you were honest. Yes, you have to speak the truth. They were honest. Somewhat negative is honesty.
Mm-hmm.
Giving it a shot is honesty. But this person we don't need. We need somebody that's going to say, I know I can be fair and partial.
Mm-hmm.
Not, I'll give it a shot. I think I can. No, this is not the little choo-choo train who thought he could. This is not the process. Josh, what's going on in my pot real quick?
It's boiling and bubbling and jumping.
All right. Is the water evaporating over there?
I don't know.
Check it out for me, baby. That's my Josh. You know my Joshy.
It's boiling and bubbling.
Oh, it's going down. Turn the pot off, please. No, you're not, Josh. Stop it. Let me go on mute for a second, guys. Give me a moment.
Okay.
Okay, guys. Sorry about that. My apologies. I had to serve the little people. So the husband fell asleep. I'm trying to wake him up, but he's asleep. So okay. So yeah. So the I give it shot is just, this is scary for me. Like, this is like, wow, it is a mistake. You know what I mean?
And I could kind of see why the other side is, so upset when they see some of this stuff.
Of course.
Just to be fair, because it's like, dang, like, but it's like, how could you be mad when it's like his own attorneys just let it happen too?
Right.
And
right.
he's there and he's supposed to be assisting in his own stuff as well.
Right.
So you can't just blame, everybody else.
Right. And then juror number 7 also revealed his questionnaire that he had heard about the case and the alleged crimes, and that trial counsel did not ask the court to question the juror further about what he heard specifically or where he heard it. The court merely asked the juror whether he could put aside what he heard and rely on the evidence presented in the case. Then juror number 8 also disclosed that he had heard about crimes defendant is alleged to have committed, and further indicated that he or she believed that the allegations related to another case in another state. Again, trial counsel failed to probe what precisely the prospective juror had heard or conduct a meaningful inquiry into whether she could be fair given what she had heard. Mm-mm-mm. You want to read number 9?
Okay. Juror number 9 also indicated that she knew that the defendant had issues with the law, but could never say exact what for. She also described the Me Too movement as the power structure of the male-dominated move industry has been turned on its head. Again, trial counsel did not ask the court to question this juror about any details she may have heard about the defendant's issues with the law, nor did he ask the court inquire about the defendant's views concerning the Me Too movement and role in changing power dynamics in the male-dominated movie industry. Juror number 8 similarly disclosed that he or she saw the case mentioned on the news when he was first being investigated, and that she had read or seen that he had allegations of misconduct lodged against him. Shockingly, trial counsel did not ask the court to follow up on any of these important revelations to determine whether the juror was qualified. Juror number 12 offered several concerning answers in response to the questionnaire. Question 29 highlighted, have you read, seen, or heard anything about the case, the alleged crimes, or the people involved? The answer was yes. The question, describe in detail what you recall reading, seeing, or hearing about, etc. Answer, sex with minors. Specific details do not come to mind. Parodies on TV regarding the details of the defendant's personal life. SNL, Dave Chappelle was in jail prior, then released.
Okay. So basically, they fucked up. Point blank, period.
Mm-hmm.
They fucked up. They messed up. They messed up. I'm not even continue to get into the rest of all of that because we know what it all was. I read it, we went through it, but I'm just going through what I think is where they went wrong. And due to these factors, R. Kelly can sure get a new trial. He sure can.
And the
And
reason why
at this
these should
point,
be
he deserves,
televised.
right. At this point, he deserves one because too much shit went on. And like I said, there must have been meetings and things behind the closed doors in the chambers so that this thing could be set up the way it was set up. So, if anything, I do see a new trial. I do not see an acquittal, but I do see a new trial. Fuck it. He goes back to trial, start over again. Hopefully, this time, the prosecution can bring it harder. Come with everything you got. Bring out all them bullets, bring out the guns, and let's go. They have another shot. So let's make it good. R. Kelly has another shot. Let's see if he can make it good with the lawyer he has. Bonjean will be dealing with New York. I gather, being that she's his appellate lawyer, I'm pretty sure she will also take over his New York case when it comes through the retrial. Let's see what happens. It might just be enough where she might just say, well, I don't know if I could do the New York one, but I could definitely do the Chicago, or who knows? She might just be Superwoman. That's how they're claiming her to be over here in these streets. She's Superwoman.
You know what I don't get, Diva? Is that it doesn't matter what attorney that he gets. It doesn't matter about a new trial. It's like, aren't you embarrassed of the real evidence that they actually have on you? And like, there was some really damning evidence that they were, bringing to the trial. And it's like, don't you know everybody's listening? Like, you really want to go through this all over again? Because it's not like they don't have things on him already.
Right.
So I'm like, why is he doing, like, they're just going to bring the same evidence and you're going to hear it twice. And more people are hearing about it.
He's claiming he's innocent, so he's trying to prove to the world that he is, right? So that's exactly what he's doing. Because as a narcissist, he will not tell the truth. He will not take accountability for his actions. And the things that he has done, he does not feel that he did wrong. He feels he did no wrong. He don't feel that he was running an enterprise just to have girls. He feels like he was doing his business and the girls were chasing him. And that's his story. But yet, you go on world tours, you travel with these girls, and they're there for what? To see your shows and to have sex. Illegal sex. Illegal sex is when you have sex with a minor. And a minor cannot consent to sex legally, even if she says, yes, come and fuck me. Even if she said that, it's still illegal sex. A minor cannot consent. And if he took the girl from Chicago and she was 15 or 16, which is illegal, right? Because in Chicago, legal age of consent is 17. So if the young lady is 16 and under, and she left from Chicago to go on tour with him on the tour bus, while they're on the bus, he's having sex with her illegally because she cannot consent because she is a minor. Then he's traveling with her across state lines to get to the next destination. That is the Mann Act. Okay? Once they get to the destination, she's either still on the tour bus, stuck, starving, and waiting, or he puts her in a hotel room, stuck, sitting, starving, and waiting for him to come back so that then he can relieve himself. because that's what he said to Azriel, right? I need to relieve myself. I gotta let it go. Can you let me let it go? I want to let it go on you. Let me let it go. I gotta let it go. Until he releases his frustrations out on the young lady and then travels back with her back to her home in Chicago, drops her off, either keeps her in the crib, the studio, the hotel, or sends her ass back home. Pays her off, gives her an envelope, buys her a bag, tells her, here's money, you could go on a shopping spree, I don't care. Just do you. See you next time, I'll call you. Or the girls that he wants to keep, he keeps. Now you're going to come and live with me because I want you to be my slave. You have to be on call for me, on demand. That means I snap my fingers, you jump, you come. That's what it is, because I need you there so I can relieve my sexual frustration out on you. Because I need to have sex because I am a sex maniac. I have a problem. And on top of that, I like little girls like you. See, this is the problem that we have. This is R. Kelly's situation. This is what the prosecutors are trying to prove. And I think they do have the material, they just didn't do it quite as strong as they should. The next time, these ladies are going to get it right. And he's still going to be convicted. And I think being that they brought up the parents will wind up going into the next trial. The parents didn't even show up to the trial. Those parents were not there for that little girl. Well, I shouldn't say little girl, for that woman, that young woman. AC went to court to testify by herself. Her family was not there. Why? Because there was too much dirt and they didn't want to hear the truth. They didn't want to hear the facts. They didn't want to see nothing that was going on. They were trying to hide their own complicity to the whole fact of them knowing where their daughter was, knowing that they enticed their daughter to entice R. Kelly. And also for them to personally get monetary gain for themselves, to have businesses to work with this man, to work with him and to maybe get into a business with him, to help their daughter's career grow, and to maybe one day be family and maybe Azriel marry R. Kelly and have grandbabies, things like that. So that's probably why they didn't even show up to trial. Now, go ahead, Noonie. You wanted to say something, baby?
Oh, no, you covered.
That's crazy. What's up, Karen J? What's up, Mama? What's up? Hey, Take. What's up, baby? You back? What's up, lady? Hey, honey. What's up? What's up, honey lady? What's up, baby girl? You back too, Mama? Okay. Let's see what y'all saying. All right. Rockin says, I think the defense attorneys did exactly what they were supposed to do. Tried to get a retrial, but the supporters aren't thinking he will be locked up longer. Well, you know what? If he gets a new trial, it doesn't matter because he still has Chicago. And being that he still has Chicago, he's not going anywhere because he has no bond. He has no bail. So he's going straight back into jail. He's going to go straight back to Chicago to wait for his New York trial to start over again. So he's not going anywhere. He's not coming home. He's not. Let's just remember, he has another case. So if this case, this Eastern District of New York trial, decides to become a new trial, he still has to sit and be transported to the MCC in Chicago to deal with his federal case there. So he's got to sit and wait until his New York trial begins. So in the meantime, he's going to be having his Chicago trial going on. Once that's done, he'll be convicted of that, and then he's going to have to wait for sentencing. But in the meantime, while he's sitting in the MCC, he's got to wait until the Eastern District of New York trial restarts. Then once that restarts, they'll transport him back to New York. So he's not going anywhere for a while because he's going to be convicted again. And then he's going to be convicted in Chicago. So he's not going anywhere. They said he would be out by February 14th. He's still sitting there. It's March 1st. Tick, tick, tick.
By Valentine's Day.
Okay. This seems real suspect to me. It's almost like the defense let this be admitted due. TK, maybe they wanted to be able to, I guess, let this be admitted due to, maybe they wanted to be able to file an appeal after the fact. Yeah, I think so too, honey. I honestly think that that's what their strategy was. Even with the retrial, he will still be found guilty. It's the evidence for me. Sex with minors is illegal, even if they wanted it or because he can sing. Lock his complacent ass friends too. Exactly. Honey says, since they didn't really have a defense to begin with, ISD, so that's sorry. I don't know what ISD stands for. Let me know what that stands for. But why didn't the defense object to this juror? I'm calling bullshit. Exactly. It's weird, right? I believe that it had to do with they set this up. Not if they are able to make an unbiased opinion. Why didn't the defense question these jurors more? Right. Either side. Bon, he is guilty of sex with minors, manipulation, bribery, intimidation, and more. Facts, Robin. Where was the defense, really? There was no defense. You're absolutely right. And he deserves a new trial. Let's give him that, yo. He deserves a new trial. The defense was put in place just for this purpose. Why no objections to these jurors? Right. That's what I said, Rockin. I believe this was part of their defense. I think they set this up for an appeal. I said that when they kept messing up. She said, one moment, please. I need a... Okay, yeah, I'm going to do the same thing, girl. I'm going to play this last little video. I'm taking you guys out with this last video, and then I'm ending the live. Truth said he couldn't buy this one because he has no money, so they decided to throw the trial. You know what? That's a good observation, Truth. That's a good one, too. Yeah. Take agrees. I agree, too. Yes, we agree on that. Yes. R. Kelly knew what he was doing. Yes, we agree. Yes. The setup started with Greenberg. Yes. I don't know if Atmos knows I'm live. I don't give a shit. He's doing his thing. I'm doing my thing. Listen, y'all can watch the replay. That's what the replay is for. I love my brother Atmos. Let him do his thing. Yeah, right? That whole give it a shot. That shit was crazy. I don't know that Atmos was I didn't know Atmos was live either. He must have been live while I was live. It was RK's plan. He thinks he's slick, but not this time. He's going down. Yeah, there's a preponderance of evidence. They can bring out a lot of other things that they didn't bring out the first time. Remember, they just brought out what they needed that was necessary to corroborate and tell their story of what happened and how he abused the girls and the story of how his enterprise came about. So they just used certain pertinent information, direct evidence and circumstantial evidence to bring together to try to convict him, to prove beyond a reasonable doubt that he was guilty. Done. I'll have to catch his replay. Me too. I'm gonna have to catch it too. Also, it's not like there was one hold out though. The decisions were unanimous. Exactly, Take. It was a unanimous decision. Those trials are so expensive. They really are. The appeals. This is why I think R. Kelly just wound up dropping everybody and keeping Bonjean, because he doesn't have the resource, the financial resource to fight all of this. So Bonjean's like, listen, I'm your best fucking shot. Okay. Thank you for the cat. The super chat, mama. Thank you, baby. Yes, tomorrow is the birthday. Yes, I am the birthday girl. We are going to party. And my other sisters, my other Pisces sisters are going to party. Wing's birthday is tomorrow too. My sister's birthday is tomorrow too. We are twins. And you're absolutely right, Truth. They are very expensive. And they planned this with that in mind, thinking that the government is not going to spend the money. I mean, the government has unlimited resources. So there's no issue with them bringing experts and witnesses and paying for hotels and flights and all these things. They don't have those kind of issues. And you're very welcome for bringing you the information, honey. Too legit to acquit. Yo, Karen, stop playing. Exactly. Hashtag too legit to acquit. I love it. When there's a new trial, would that probably be in 2023? I think so, Karen. I think you're right, baby. That number sounds good to me, baby. I don't know when, but definitely 2023, mamita. He feels like he didn't do anything. Yes. It's just sex for his fetish. Exactly. This man really needs help. He has had so much time to get it together and the money for the best doctors. What is going to take for him? What is it going to take for him to get the help he needs? You know what? Truth, so much he could have done when he had the money that it's too late now. The only real help he's going to get now is in prison. And hopefully in prison, he can get the actual counseling and rehabilitation that he needs. I hope he doesn't fall into the system and continue to be the narcissist that he is. And I hope he develops a way to humble himself. Because I see him continuing to do his crimes, but manipulating young men in jail. If he does that, I mean, it's a crime, but will he get caught? Will he be reported? And if he does continue to commit his crimes while he's in jail with minors and sexually abuse people, manipulate them, God forbid somebody doesn't wind up hurting him. You know. Mm-hmm. No one cares about his sex life, but I care about the abuse and manipulation of minors. Thank you. That's our fight over here. His sex life, we don't give a fuck. He could be a freak all he fucking wants. He could have menage a trois, orgies, parties with orgies, whatever, swinging parties, whatever. He could even have poly relationships. Who cares? The point of our fight is the abuse of minors. His illegal sex with minors and his abuse of minors. If he would have done this with adults, it would have still been a problem because he was abusing and manipulating women. Okay? You know, it would be like in a domestic violence abuse. That's his girlfriend, but in the process of their relationship, she's being abused physically, emotionally, mentally, verbally. All of this is what we are against. This is why we're here. This is what we are here for, to support these women who go through these things. We're not out here advocating in big ways, but we're advocating on YouTube. And that's a start. True Strong says that was strange that they were not at court. Yes, especially knowing the type of supporters that this man has. Why not be there to make sure that your child that you have not been around in 5 years is safe? Facts. Facts. And Honey said, happy birthday. Thanks for all the information today. You're welcome, Mama. You rock too, baby. Shop. Hey, Chocolate. What's up, Chocolate? What's up, Mamita? She said, he doesn't think he did anything wrong. He really don't. He's a fucking but-ump. Chocolate, he will never admit to his crimes. That will be the reason he gets the max. That will be the reason he gets the max sentencing. Yes, my birthday's tomorrow. Adiva birthday tomorrow. Hey, puppy. What's up, baby? We was talking about you. I found out you was live and shit. I don't know what was going on, brother. I went live and you went live. I said, I don't give a shit. It is what it is. People could watch the replay. That's what YouTube's there for. Love is all around. I see you here, Miss brother. What's up, papi? Oh, thank you, baby. Thank you for the super chat, papi. Thank you for showing me love. In case I don't catch her live, just didn't want to forget. Okay, Chocolate says, T-Bam, I really, really hope he gets the max. He doesn't need to be on the streets anymore. I hope so too. I hope, you know, even if he does get like 40 years, it's still, even if he gets 40 years, it's still a maximum life sentence for him. I mean, come on, he's 54 years of age. What, he's getting out of jail when he's 94? If he makes it to be that far, you know what I mean? Right, T-Bam. The appeals will take some time to be heard. Hey, Latrice, what's up, mama? And thank you, ladies, for the birthday shout outs. Yeah, my birthday's tomorrow, guys. Tomorrow we're going to party and bullshit and party. Bam, I have been back and forth from Atmos and this page. I am lost. What? I don't know what. Hey, Tanisha. Hey, Tanisha Get-ins. Welcome, welcome. It's high time that he gets jail time for his abuse of brown and black girls. Exactly. Even white girls. He has white girls in there too. And that girl, Christy Lee. And I think that other girl, Saray, or whatever her name is. Thank you, Chocolate. Thank you guys for the birthday shout out. I watch both spreading the love. There you go. Watch us both on a device. Yes. That's it. That's it. That's the way to go, guys. Okay, my love. I'm pretty sure your internet's bugging out. Mine too. It's being unstable. But I'm glad you guys can still hear me. Nuni, thank you so much, my love. T-Bam, you was up there reading. Girl, you multitasking queen. That's what we do, yo. That's what we do. So now I know my girls T-Bam and Nuni will be reading. Y'all. Karen J said I was on the iPad and cell phone. Yes, I'm still live, mommy. I'm teaching. These are teaching moments. Ty. You know how it is when I do my teaching moments. Girl. I thought I was bad with the laptop, iPhone phones. No, baby, you are not bad. We all multitask. Listen, it is what it is. We got to show love. And thank you once again, Tombella. Nicole, thank you, mama. So, to end this live, I'm going to end this live on a note. You know me, Ty. Now, guys, I'm going to end this, like I said, with a video from a juror number 5 from the O.J. Simpson trial. That's awesome, T-Bam. I hope you get the courage to come up here with me, baby. Thank you, True Strong. Thank you, Mama. I'm glad. I hope you guys learned a little bit about, and got a better understanding of what voir dire is and how the whole process goes and what can be allowed, what's not allowed, and what Bonjean is trying to fight for. And we all over here agree that, yes, there might have been some type of strategy amongst all of them to have to start over again for R. Kelly's due process of his civil rights. Because at the end of the day, we do want him to have a fair trial. Even though we all think he's guilty and we know he will be convicted again and again and again. So it is what it is because of the preponderance of evidence into which we have heard some of, we don't know all of, but hopefully the prosecutors can come stronger the next time around. And he will still be convicted at the end of the day. So as I said, I wanted to end this live with just a clip. Well, not a clip, but it's going to be a whole live. A whole video here. We're talking about like another hour, guys. So, but it's very interesting. And I think it's very informative so that you guys can see, if for those who have never been jurors, and actually went through the voir dire process and was actually in a case being the judge, being the jury for the case. I think this is a learning lesson, you know, so that when you guys do, like I said, get summoned to do jury duty, do your civil duty. Don't don't diss it. Do your civil duty, man. Go. Do the experience at least once. Just get that experience. And they do pay you. You know, it's not like you're sitting there all day and you're not getting paid. You will get paid. Unless you work for a company that has more than 10 employees or 11 employees or something to that nature, then either your employer will pay you for your days off according to the way they are and their policies with their human resources, or you won't get paid at all. So that's how that goes. Thank you, my love. I love you, Ty. Thank you, Aisha. I believe that Diva Divine, it was a setup hoping he can get a bond, but he has that Chicago case. Yes, he has the Chicago case. He's not going nowhere. I'm telling you right now, he's not going nowhere. And you still get paid from your job. Yeah. And you still get paid from your job. It depends. Because if you have to take days off, like if you have to take 2 days off, they'll give you your sick day or your personal day. And they'll say, okay, so you'll get paid for those days. That's how they'll do it. If not, you won't get paid. You know, I know a lot of people that have been through that too. So that's why a lot of people at times want to skip jury duty because of that little process there. But just go and get the experience, y'all. Come on. Don't be such party poopers. It's an interesting experience being called for jury duty. It is. I said I was called, but I never actually was put onto a case. I did fill out the questionnaires for one, but they didn't put me in the box. They got the people they did it. So the other people that were sitting and waiting were dismissed because they took the people, the first 2 set of people. You know what I mean? So it happens. It's been, oh, I've been selected 1 of the 3 times. I'm good with jury duty. The C plus was my job, paid me 2. Okay. All right. So like I said, I'm going to end this with a video from juror number 5, and she talks about her experience being a jury in the O.J. Simpson trial, which we know was a very high profile case. There was a lot of things that went on that were corrupt. People lied. The glove didn't fit, so he must be acquitted. You know, there was blood here, blood there, but it was tainted, and all these things that went on, and that was just another circus. That trial was another circus. I wish to God that he would have went for another trial. If they would have done a retrial, you know, if he would have gotten convicted, I wish he would have gotten convicted and did a retrial. You know, like, I don't know. It's just so weird. They should have just, I don't know, like, I don't know how to even explain that situation, but it was crazy, y'all. She said, they sent me something in the mail last week. Not interested. Well, Ty, you have a medical reason. So you're all right, you know, because you won't, being that you are disabled with your handicap, I don't think that they would anyway. So all you have to do is fill it out, let them get a medical notice and send in the medical notice. Either by mail, you call them, fax, or something like that. It's her civil duty, but she has a legitimate excuse. She does. She has a legitimate excuse to be pardoned from jury duty. She does. So I'm going to take you guys out with this one, all right? Let me move this. Hold on. I'm going to share my screen. You guys. Oh, where is it? Hold on. Oh, wait. I got to put the video up. Sorry. I didn't change the video. Give me a second, guys. All right. Give me a second, y'all. Okay. All right, let's get it together here. Where is my watch list? Okay. Okay. Here we go. So the title of the video is Juror Number 5. And it says 58 days jury duty on the O.J. Simpson civil trial. She was in the civil trial, not in the criminal trial. Okay. I thought it was the actual trial, the criminal trial. Bleh. I thought it was the criminal trial. It wasn't the criminal trial. It was the civil trial. I was listening to her, her testimony and what she went through, and wow, what she thought about the evidence and all that stuff. Very interesting. Okay, I have to restart the video. Okay. 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 All right, it's doing its thing. It's loading, guys. Sorry. Now this came out on HBO. And it was called the O.J. Simpson Civil Trial, the HBO documentary in 1999. Let's see if I can get it open here because it's playing games with me. If it's playing games with me, I'll probably just end the live. And okay, I think it's gonna start. Here we go. Let me see. Okay, I'm gonna put it on pause. There we go. Actually, I'm gonna let it play in the meantime. All right. Okay, I don't know if you guys heard me.
Blood would have spurted out 12, 15 feet. A big slice into raw meat, but red, so you can see that it's flesh. This young man died in a bloody heap, staring at a helpless woman. I can be the keeper of the horror. So this is how it started, with this jury notice that came in April. And everybody I talked to said, I just throw those things away. And I couldn't really do that, even though I did let it sit around on my desk all summer long. So when I finally sent it in, I got this official summons for the very next week, September 19th. Now, I knew that jury selection was going on for the Simpson civil case, but I didn't really make the connection because I just rarely think that anything of any significance has anything to do with me. So I'm driving down to Santa Monica, looking for the courthouse on the map. And I saw those tents and cameras and all those crowds, and I drove right past because this is LA. I thought it was a movie shoot. So I turned into this big official looking building and I said, I've got this jury summons and I'm looking for the courthouse. And the guard said, you want to be with them over there. Oh, this is that. So by the time I got over there, just getting from the parking lot and being one of the ones allowed to walk down the sidewalk with the crowds behind the barricades was like getting into Studio 54. The first thing they told us was that we had to sign a form saying whether this would be a medical or mental hardship. So I'm thinking, I could do this. Because I work freelance, designing scenery and lighting. And I never work in December and January anyway. I just lay around. So I could do this. That night, I had a meeting with some producers who wanted me to design a set. So I took out my little jury badge, and all I'm allowed to say is, it's a high-profile case, potential juror, Santa Monica courthouse, may take several months. And I said, you know, they're going to pick me for this jury in Santa Monica. And so, of course, they knew what I was talking about, that it was the Simpson case. And the woman said, oh, Dina, they call 4,000 people. They're not going to pick you. And I don't know how, but it came right out of my mouth. I just said, you don't understand. This was decided before I was born because I knew it. That first day, I knew I would be selected.
The individual jury selection like this, where you bring one juror in the courtroom at a time, always takes a long time. So you don't poison the other jurors by the comments of any one juror.
Once again, race playing a major issue in jury selection.
Jury selection took about a month. The first questionnaire was 20 pages, all about the criminal trial and all the publicity. It was like taking a test that I was flunking because I was so in the dark about all this. Because the feeling I had had during the criminal trial was like when everybody in the whole country was watching Dallas and I didn't. I thought Miss Ellie shot JR. And then they asked the question about the Bronco chase, where you were, what you were doing, and I didn't even know it had been going on.
5 freeway, past the 55 freeway. O.J. Simpson is believed to be in the white Bronco that you see in the center of your picture, followed by as many as 9 orange cars.
No, don't. Nicole, that's all I'm gonna do. That's all I'm trying to do.
Think about everybody else, all right?
Video on the freeway. I could do it in a field. I want to do it at her grave. I want to do it at my house.
You're not going to do anything.
So then they ask, have you ever expressed any opinion about the guilt or innocence of O.J. Simpson? And I said, yeah, I've expressed them all. Some days guilty, some days not guilty, depending on who I'm talking to.
Hey, push before the game, pusher! Remember the victim!
And some days I was just convinced that there'd been a big frame up.
100% not guilty. Who framed OJ? I don't know. Best of luck, man. Best of luck. Yeah, man, we love you.
But most often, who the hell knows? So the first questionnaire eliminated all but like 100 people. We had to go back in and fill out another questionnaire, another 22 pages. And this was all about yourself and your personal experiences with the police. And I know I must have sounded like country come to the big city, because when they ask about any negative experiences with the police, the only thing I could say was when I was a teenager in my hometown in Mississippi, the police would follow us real close when we were driving my dad's car, because he was real well known around town for speeding. My opinions about interracial marriage, well, I just think marriage is a bad idea to start with. And finally, your opinions about O.J. Simpson as a person. Until this happened, I thought he was an ex-basketball player. So I think being ignorant of the criminal trial and some infantile idea of athletics in this country, I think they just must have thought I was some vacant-minded slate who they could really mold my mind. One of the things I suspect they were thinking was, she's got a racial mixture we might be interested in. What is that? Is she black or is she white? Or some mixture? Because I know everybody, when they meet me, that's what they're thinking. What is she? And the only people who are honest at all are little kids who just ask, Miss Mullen, are you black or white? So after days of this, finally, there's just this instant when very casually one side says, this jury is acceptable to us as presently constituted. And the other side doesn't object. And we had to stand up really fast, and we're sworn in, and we have to promise not to talk to anybody and listen to all the evidence and don't form any opinions. And now go back downstairs and the deputies will tell you what to do each day and where to park. And so we're jammed in this little hall downstairs. It's right near where they keep the prisoners. And it was the first time that we even got to introduce ourselves by our name instead of our number. And so, hi, I'm Dina. I guess we're going to be spending some time together. And that's when I got to be juror number 5.
There were opening arguments both outside and inside the courthouse, signaling the start of O.J. Simpson's second trial. But inside was again accused of being a double murderer.
In opening statements, the defense is basically assaulting and attacking the character of Nicole Brown Simpson.
Actually, going to jury duty every day was kind of like having a job, because you had to go every day and stay all day and not leave. Now, as an artist working freelance and on my own schedule pretty much my whole life, I had not been this tightly controlled since I was in grammar school, because you're told when to be there, stand in this part of the hallway, wait right there, be quiet. Now go in that room, pay attention, take notes, use only these notebooks, and now it's time to take a break. Here's the time for your lunch. At the end of the day, they put you on the bus and you go home. So I had to decide real early that if I didn't just give myself over to this controlling process, I was going to be really frustrated. even though we had no control, we had all the power, because everything being said and done in that room was for our benefit. And it wasn't a very big room at all. The judge was maybe 10, 12 feet away. In the witness box, if somebody were sitting in there, I could have just popped them with a rubber band. And the lawyers were right here in front of us, with Fred Goldman, Dan Petrocelli, and then beyond them was Simpson and his lawyer, Bob Baker. And beyond that was the audience with all the families and then all the press. And we couldn't do one thing to indicate what we were thinking, how we were feeling, or responding to what was being said, because we were on display like animals in a zoo. Everybody was watching us, hoping to get some sign of what we were thinking. I mean, you couldn't even like squirm around in your chair. Or maybe you had some bad chicken at lunch and had a funny look on your face, because if you did anything, they would just get big eyes and the reporters would just start writing things down.
I saw 2 of the 12 jurors who were teary-eyed.
The jury couldn't help but see that. They didn't look uptight or anything like that. They must not talk to anyone. They must not conduct any of their own research.
Well, sure, you would like to have the jury relate.
The jury is being very methodical.
We tried really hard to just turn to stone so we could resist them.
The decedent was wearing a short black dress that was bloodstained and a pair of black panties.
9 days into the trial is when we saw the autopsy photos. And after that, everything changed. Because let me tell you, there was something to see. And how they had them displayed so that the families didn't have to look at them. They were here, so we had to turn into the audience and right into the press, who were just gawking at us, trying to get our reaction. And there was one juror who wouldn't look at them, and the judge had to say, "This is evidence, you have to look." These are the drawings that I made from the photos of Ron Goldman lying on the autopsy table. And he's got all these cuts here and here, here, all over his arms, and these big, huge gashes on his neck. And the thing is about these wounds, it's like a big slice into raw meat. They're just laid open. They're all clean, but red, so you can see that it's flesh. And this little thing right here, this is what they said killed him. It's tiny. They said the knife went in 5 inches and pierced his aorta, and his blood pressure fell, and he collapsed and died. And these photos of Nicole Brown. We had seen photos of her that very afternoon at her daughter's recital. And she is a beautiful woman, very California looking. She's got this great tan. But in this photo of her, her skin is so drained of blood that it's like paper. It's this white. Because they said she bled out. That's how they knew that she was down on the ground when she was killed, because all of her blood is in a big puddle underneath her. That the pressure in the heart is so great that if she had been standing up when she was cut, that the blood would have spurted out 12, 15 feet. And that's why there was hardly any blood on O.J. Simpson, because she was down on the ground and she bled out. And it's this photo right here. You can actually see her windpipe. It's right here. It's like a piece of hose. It's been cut. It's just sliced and laid wide open. There was another photo when I was looking at the contact sheet, and she's laying on the table, and they've got her head bent all the way back so you can actually see how deep this cut is. And it's like a Pez dispenser. It's bent so far back. Because they said the knife actually nicked her spinal cord back here, and her head is barely attached to her body. That's how deep the cut was. And it's these photos that I keep in my mind when I think about her, about how her head got cut off. And keep them so close, it's, in my mind, it's like where I put the photos of my family in this photo album in my mind. That's how intimate I feel towards them. But before that, they were just dead bodies, just evidence. From that moment on, everything I did had to do with the trial. Sitting in that courtroom with O.J. Simpson. Someone tracked white paint through the theater. I saw bloody shoe prints. Standing in my kitchen, cutting up an orange, I see this knife. It's 5/8 inch. Driving down the freeway, listening to the radio, that Beatles song. I'd rather see you dead, little girl, than to be with another man. You better keep your head, little girl. You won't know where I am. And I lost my breath. I almost wrecked my car. You're so isolated in your mind. The only thing you can do is write it all down. And that's what I did. I wrote and I wrote and I wrote and I wrote and I wrote. The day O.J. Simpson took the stand, that courtroom was jammed.
O.J. Simpson took the witness stand promptly at 9 o'clock this
Angry
morning.
at times when questioned about domestic violence.
And he said the two shared a strong physical, sexual relationship, slapping or punching Nicole. In fact, he said, quote, "It didn't happen."
It looked like he was somewhat making it up as he was going along.
And this moment is one of those moments of real life drama that's so much better than anything anybody could write or put in a movie or put on stage, because he was so there, and he's really big, which was one of the first things I had noticed about him, is he's got this really big head. I mean, literally, it's like this big. And he's got these big hands, and he makes these big fists. So Dan Petruccelli is asking him about the domestic violence and beating his wife.
He's O.J. Simpson. I think you know his record. Could you just send somebody over here? Okay, what is he doing there? He just drove up again in a white Bronco. But first of all, he broke the back door down to get in. Okay, just stay on the line. I don't want to stay on the line. He's going to beat the shit out of me. Wait a minute. Does he have any weapons? I don't know. 4221, I need 825. Is he inside right now? Yeah. Okay, the kids are sleeping. You think he's still going to hit you? I don't know.
And they have these big photos up on the display screen of her with all these bruises. And he says, "Look at that. Did you do that?" And Simpson goes, "Well, I don't know. We were wrestling. I had her in a headlock, and we were wrestling." And he's got his fist like this, and Petruccelli just looked really surprised and said, "With those fists in her face, you were wrestling?" And he just took his hands and put them right down between his legs, and he got angry. The vein in his head starts pulsating, and his jaw is clenched, and his eyes go black. And I thought he was going to fly right over the witness stand. But later, after lunch, when he got back on the stand, he is so calm. And I have written in my notes, medicated? He looks drugged. But we couldn't even talk about it for 2 months. When we're in deliberations and we're talking about that day, and one of the other jurors has written, Valium? So, day after day, we would go in and get all this information, all about DNA and cell phone records and police logs, and hear all this testimony all about back gates and front gates and dogs and blankets and ice cream and who went where and what they carried and how long it took and who didn't go somewhere else. And we couldn't talk about any of it. And we couldn't ask any questions. The one thing that we all had in common was the one thing we couldn't talk about. We couldn't even mention his name. And there were a lot of times when we didn't even get into the courtroom and we had to keep ourselves busy. Somebody brought in a Jenga game, somebody else brought in Yahtzee, and my contribution was to bring in coloring books, enough for everybody to color with pencils and crayons, and origami paper. And these were the things that I colored. And I spent days on each one. This was early on. It's kind of nice and simple. This one, during the time that Simpson was testifying, was kind of dark. And this, I think, is my favorite one. It was finished at the day we finished the verdicts. And having all these toys around was like being in kindergarten. I even brought in a blanket and a pillow so I could nap right after lunch. I didn't care if people watched me drooling on the floor, just crawled up under the table and snoozed.
If you had to point to one thing, it's the shoes.
FBI photography expert is expected to testify that the photos are real.
OJ could never explain it.
The day the Bruno Mali shoes were introduced, you could tell something was up. We didn't even get into the courtroom till 11:30. And when we got in there, everybody was all in a lather. And the judge was all red in the face, and the lawyers were huddled up and making lists and calling out evidence items into the record. And then there they were. These 30 photos of Simpson wearing those Bruno Mali shoes. They were huge. And an enlargement of his feet, this big. And at first, all I could think of is, they spent a lot of money on this. The real power of these photos was when Simpson was on the stand and Petruccelli is asking him, photo by photo, is this your head? Yeah, that's my head. Is this your jacket? Yeah, that's my jacket. Are these your pants? Well, I'm kind of a little bit more snappy dresser than that, kind of baggy. Are these your shoes? No. Those aren't my shoes. Every single photo, and then the blow up. And this takes all afternoon, on and on about pants and shoes and belts. And every time he got to the shoes, he says, no, those are not my shoes. And that he never owned those ugly ass shoes. And just listening to this guy, it reminded me of listening to one of my nephews when he was about 7, and he would kick his brother underneath the table and say, I didn't do anything. Those aren't my shoes. I didn't kill her. So finally, it's the end of January, and we're in closing arguments. And Petruccelli is responding to this comment that the defense lawyer, Bob Baker, had made, that anybody with $200 could bring a civil suit against anybody. So he reaches in his pocket, pulls out this big wad of 20s, and he says, we would gladly give this back if we could see Ron Goldman come walking through those doors. And for a split second, everybody turned to look. I mean, all the lawyers that were facing the judge and all the reporters looked back over their shoulders like expecting something. And I know I really thought that I would see this tall, lanky kid just come sauntering in. And it was just the barest flicker of hope. You know, like when somebody's dead and you think you hear their voice in the next room, and for about that long you think they're not dead. Except the only person who didn't look back was Fred Goldman. He was sitting there watching us, and he just looked down. It wasn't reported in the press that way. After the trial was over, and I read about that, they told all about the big dramatic moment when he shipped this big wad of money. But this other moment was the first time in the whole trial that I ever had any sense of Ron Goldman as a real young man. By the time we got to deliberations, we were so ready to talk. And at first we had to gossip about some of the things we saw, like this one lawyer who'd quit wearing his wedding ring and had his wife left him or he just got fat. It was over an hour and a half before anybody could even say O.J. Simpson's name. And I remembered the exact minute it happened. One of the jurors said, if O.J. Simpson, and I just jumped. My heart got stuck in my throat, and I thought, this is it. This is what we've been waiting for. And there was so much evidence. All this stuff was jammed in this tiny room with all of us in this huge table. This room was half the size of my bedroom. So we had everything out on the table, and we had those gloves. And I put them on because I wanted to see how they fit. And I could see how really big they were on my hands. And they had holes in them. I wanted to try to think about how those holes got there. And I guess I kind of just forgot I had them on because I kept them on and was talking and talking about something else, I guess for a really long time, because finally somebody said, Dina, my God, what are you doing? Take off those gloves. There was one guy on the jury who did not want to go back to work. He had to have an hour and a half at lunch, 2 breaks in the morning, 2 breaks in the afternoon. And I don't know if he was scared to go back to work or if he just never wanted to go back to work ever. Because he just wanted to stretch this out like he was on vacation. And there was a moment during deliberations when he said, now I know he killed her, but, and I just lost my mind and I went completely insane. I don't know what the but was going to be, but I reached over and I grabbed the big book of autopsy photos and I was just flipping through till I found the picture I wanted. And I said, killed her? What do you mean killed her? He cut her fucking head off and he's guilty. And I just threw the book at him. And the foreman says, sit down and shut up. And this guy goes, don't tell her to shut up. And this other guy goes, yeah, you shut up and quit calling us stupid. You've been insulting us all week. And we were just yelling like it was the most important thing we'd ever done. And at that moment, it was. And it was all such hard work. I went home every night just spent and would eat and get in my pajamas and go to bed at about 8:30 and dream about all the evidence. And after 5 days, we were ready to vote. And the first vote was unanimous. And I think everybody was surprised that we all agreed. Now, the judge had ordered us to deliberate till 5 o'clock every day. And here it was, 3:45, and we thought, great, we get to go home early. But that's not what happened. We buzzed twice, which is the signal that we've got a verdict. And the judge took our verdict form and sent us back downstairs. And we had to wait for all the lawyers to get to the courthouse with all the families. Since we were used to leaving at 5 o'clock, they hadn't planned dinner for us. And, we're getting kind of cranky and kind of freaked out because now we can hear what's going on outside. I mean, we can hear the crowd of people crossing the street. And it's really frightening because the helicopters were above and we can hear this big roar going around to the front of the courthouse. And still we're just waiting until finally we overhear on the walkie-talkies. The Goldmans and the Browns are in the building and we're ready for the jury. At 7:15, they march us back upstairs and into the courtroom, and it's about 90 degrees in there. It's a county courtroom. They turned off the air conditioning at 4:30, and I am just sweating, and I'm all woozy because I haven't eaten, and I sit down, and there's Petrocelli sitting right there facing Fred Goldman, and they both just looked awful, like they were going to throw up or pass out. And I didn't want them to have to wait another minute. I wanted to say, it's fine, it's going to be okay. And it took a while for the bailiff to get everybody settled down because it's just jam-packed with crowds all the way, wall to wall. So finally, everybody's settled. The judge comes in and he asks for the verdict form from the foreman, hands over this big envelope with our verdict. And when the clerk reads the verdict, there is this big, huge applause and shouting, and the judge banged his gavel on his desk and said, "Quiet in here, I'll clear this courtroom."
A loud roar goes up as the jury decision is read.
The jury has found O.J. Simpson willfully and wrongfully caused the death of Ronald Goldman. The jury has found O.J. Simpson committed battery against Nicole Brown Simpson.
And this was the first time that I ever felt anything towards O.J. Simpson. And it wasn't really anger. I just thought, I can call him a killer to his face.
A
I've never personally shaken hands with a murderer. It's good to see you. Thank you. Very nice meeting you. I've never personally shaken hands with a murderer. It's good to see you. Thank you. Very nice meeting you.
Does that hurt? And I just felt like poking him and saying, you cannot lie to me. Because what was he going to do? Kill me? Other than that, I really have no feelings towards him. I knew that after all these months of being protected and sheltered, that we were going to be assaulted by the press. And it was terrifying. Leaving the courthouse, we're in two vans just tearing through Santa Monica with this long string of reporters behind us and helicopters. So the deputies pulled the vans into this underground parking lot to get us all into one van. And one of the jurors just ran off through this parking lot. They couldn't stop her. And she went and got on the city bus. So that by the time we got back to our secret parking location, it seems like there were hundreds of reporters around this cyclone fence trying to get at us. We couldn't even hug goodbye or say, see you later, because we wouldn't see each other anymore. We didn't even know anybody's last name. So I just got in my car and took off. And that night I went to hide out at my sister's house because around my apartment was just swarming with reporters. So I put on this blonde wig and we drove around the apartment building, around and around, eating ice cream and just laughing and watching these guys just swarm all around looking for me. Because it was surreal and it got really weird real fast because the Today Show called up and they wanted me on Saturday morning and I had to work on Sunday and they said, oh, that's not a problem. We'll fly you out on Friday and fly you back on Saturday night.
Were you also surprised at how much attention was focused on you after? And we're watching every movement you make. Either of you have plans to do books?
I had 4 years of college, 3 years of graduate school. I never turned in a paper on time. I don't think either. Even though I thought I was really prepared for this, still it was like being shot out of a cannon and just flying through outer space.
This hour of Lee's life after being a juror, deciding someone else's fate forever changed my own. Come on back and join us.
From the Lisa show, I got this little radio shaped like a TV. See, it's not a TV, it's a radio. But it's shaped like a TV because she's on TV.
Would it make you uncomfortable or frighten you to come face to face with him, do you know?
I don't think so. I wasn't really very interested in him before, and I'm really not interested in him now.
She's the tell it like it is lady.
There was this large group of people who went to the courthouse every day to watch us and thought they got to know us. And they were like our fan club because they had a couple of parties for us after it was all over.
Hey, I'm Barb Sturgis. Good to see you. Wow. Thank you so much for coming back.
And they gave us these T-shirts. Although this one kind of creeps me out, and I've never really worn it. Don't even keep it with my clothes. When I think about what I know and how it's changed my life, because I could look at those pictures and not turn away, and I could take those images and keep them and make them precious to me, that when the world an answer, I can take them and I can say, see, this is what there is, and this is all there is. This young man he came walking down that sidewalk and he died in a bloody heap. With his eyes open, staring at a helpless woman in her bare feet and with her head cut off. Do you see? This is what there is. This is the answer.